Hey, what's going on? I got a weird one for you today. You know, when I say weird, people panic. So, this is a crazy estate case, I guess is what it would be classified as. Um, I don't even know where to start. So, we're in Kansas, and a gentleman died, and the people in his will had already died. So now there is a battle amongst his heirs on who gets his um it's just under $1 million estate. And it is crazy. Absolutely crazy. A little drama filled, a lot of legal education, and I don't like estates. I don't like any of that stuff. Worst class in college was wills, trusts, and estates. Oh, I hated that class so much. It was horrible. But we will talk about this will because I have read through every single page of every single filing, and there are a lot. Wow. Like lots of citations, lots of. Judge Ricky's got to be loving this. Seriously. Okay. So the reason I'm going to talk first is because if I don't give you some background information on what happened on paper leading up to this point, you will be totally lost going into this hearing. I was the first 3 times I watched it until I read everything. Then it kind of made sense to me. So real quick, before we get into the actual case, let's talk about when you die without a will, intestate. There are statutes in almost every state that says what happens to your assets, what happens to your stuff, who's going to get that $3 worth of change that's, buried in my couch, because that's about all I'm worth these days. So generally things pass to your children or your parents. After that, it's going to be your grandchildren, brothers and sisters, maybe grandparents. So nieces and nephews would be after grandchildren, children, brothers and sisters, parents, grandparents, and they'd be in line with great grandparents and aunts and uncles, if that makes sense. So now that you know that, let's look at their family tree real quick, because this is where it gets a little wonky. So Ma and Pa had 3 boys. And then Ma had another boy with someone somehow, somewhere. I didn't get into all that. So Larry, who we're looking at, he had 2 kids. His brother, Dennis, had 1 child. And then the half brother, Ma's kid, but not Pa's kid, had a daughter. But that daughter was possibly never legitimized. So there's no definitive proof that she's really his daughter. They weren't married. She was born out of wedlock. There was no, they say legitimized. It's such a crappy word, but basically you got to go through the court system, put it on the birth certificate, and pay child support. I don't know. So when Larry wrote out his will, this is Larry's will, he left everything to his parents. So he wanted Ma and Pa to have it all. They were living with him at the time. He wanted them to have everything. Now, he wrote this will out back in 1999. He wrote in the will, I understand I have 2 children. I do not want to leave them anything. Like, point blank, you get nothing. Nada. Sorry, nothing. All 3 of Larry's brothers passed away before him, as did his parents. He has disinherited his children. So what that leaves is his grandchildren, his niece, and his possible half niece, maybe. Yeah. So those are the people. This is our cast of characters. So hopefully that will help you understand this.
This is in the District Court of Butler County, Kansas, case entitled, in the matter of the estate of Larry Franklin Holderman, deceased. This case number 2022 PR 168. The court finds that Trent Weta appears, attorney for the estate. Mr. Cranmer, would you make announcements, please, regarding appearances?
Yes, Your Honor. Douglas Cranber and Sam Natera of Stinson Lasswell Wilson on behalf of Frank Blind, Esme Pearl, Sam and I are appearing via Zoom video from my conference room. Frank and Esme are appearing via Zoom video from, I believe, the state of Washington, and you can see their pictures on the Zoom video.
All right, Ms. Williams?
Yes, Joy K. Williams. I am accompanied by my client, Susan Davenport. We're appearing via Zoom.
Mr. Mills?
Your Honor, Russell Mills appearing on behalf of my client, Mandy Holderman, heir and issue of the deceased. She is present in my conference room with me.
Okay, Mr. Mills, can you tilt your screen just a little bit? I can just barely see your heads. There you go.
Oh, okay.
Thank
Sorry
you.
about that.
I appreciate that adjustment.
Okay.
There appear to be no other appearances on the meeting. We will begin. This matter is set for further proceedings after the court had conducted a previous hearing where construction of the will was extensively discussed. I will note, as I'm sure the attorneys are aware, that Mr. Mills made a very belated filing yesterday of an interpretation of will and application of anti-lapse.
I'd like to introduce you to a new segment called Penny Explains. So we all know sometimes dogs are smart as a whip, other times they're dumb as a box of rocks. Reddit might explain it like I'm 5, but here we're going to explain it like we're a dog. So here, for the first time, Penny's going to explain the Kansas anti-lapse statute, which is actually really simple, but comes across as really confusing. So Kansas Statute 59-615, also known as the anti-lapse statute, reads, devise or bequest to spouse or relative who predeceases the testator, issue, defined. If a devise or bequest is made to a spouse or any other relative by lineal descent or within 6th degree, whether blood or by adoption, and such spouse or relative dies before the testator, leaving issue who survive, the testator, such issue shall take the same estate which devicee or legatee would have taken if he or she had survived, unless a different disposition is made or required by will. It's further broken down in the annotations as anti-lapse statute in effect at testator's death, applicable in action to determine whether heirs of deceased beneficiary succeed in his interest in re estate of Thompson, which is still really confusing. So let Penny break it down for you. Okay, so let me give you a scenario. When we went to adopt Roxy, her littermate Lola would not shut up, crying, screaming, having a fit because we took her sister away. So we ended up with 2. They were inseparable for about a week. Then we get home and Lola disses Roxy for Rambo. Now her and Rambo are obsessed with each other. Her and Rambo have a love-hate relationship. He beats the crap out of her in the morning and then loves on her in the evening. It's like an abusive relationship. It's really bizarre. Anyways, so Rambo has his favorite toy ducky. So he writes out his will and leaves his favorite toy ducky to his girl, Lola. But Lola's scared of everything and ends up having a heart attack when someone looks at her, and she's gone before Rambo. Lola doesn't have a will, so everything she has passes on to her sister Lola. It's like a dog, except Rambo's toy ducky. Because per the rules of the anti-lapse statute, items can't pass collaterally, they have to go lineally. Lineally means up and down, collaterally means across a generation line. So, say during her, week at the pound, Lola hooked up with Stray, had a kitten. Rambo doesn't know about this kitten, doesn't even know it exists. However, this kitten is getting Rambo's ducky toy because of the rules of the anti-lapse statute. What it means is that the inheritance automatically passes down to a person's descendant, whether it's specifically stated in the will or not, unless it is specifically stated otherwise. Hopefully that explains it just a little bit. I don't know.
The title. I trust each attorney is now familiar with Mr. Mills' recent submission. We are here to discuss the status of this matter and for the court to make some ultimate rulings in the case. I want to give each attorney an opportunity to at least make a summary statement of their current position in the matter. I will start with Mr. Mills.
Your Honor, I apologize for the delay in getting my response to your request completed. I will tell the court that I spent a great deal of time trying to comply with the court's request, which, as I understood it. And so the document that I have filed is pretty much sets out the law and the facts as I understand them. Now, Your Honor, I want to make sure that the court understands that the facts that my client has provided to me are facts that are essentially from her family history, and I don't want to mislead the court in any way. But it's our understanding, or her, I should say, her understanding that the children, Frank Bly and Esme Pearl, were adopted by a gentleman by the name of Mr. Bly. And so in the first part of my written presentation to the court, I kind of go through that and how that might affect these proceedings. And if we can confirm through Mr. Bly that he was in fact adopted, I mean, it just makes sense to me if he goes by Mr. Bly, that someone named Mr. Bly did in fact, adopt him. That being the case, Your Honor, we believe that the law of the state of Washington would impact this case greatly as it relates to the adoption.
I don't quite see how, Mr. Mills. This is a Kansas drafted will that's being probated in Kansas. So why should this court look to law of the state of Washington here? I noticed that in your recent submission that if Kansas law didn't appear to be on your side, you cited Arkansas law or Washington law or some other state's law, perhaps to avoid the implications of Kansas law, I would suggest.
Why
Washington?
Your Honor, I guess the main thing that I think we have to keep in mind, Your Honor, is that the Kansas law, even in interpretation of the wills, we're supposed to determine what the intent of the testator, and even under the anti-lapse statute, that's there for the purpose of helping to us, or focusing us on, again, the intent of the testator. And so what I'm trying to advise the court of is, if you look at the statutes, you can't on the one hand say, well, he should be aware of the Kansas law, but not be aware of the Washington law that terminated these children as his children, and further terminated those children as having any right to inherit from him. So that was something that he would have known and would have taken into consideration when he was involved in this will here. I think that if that's the case, I don't think the Kansas court can determine that these children or even their grandchildren were in fact issue of my client's father, of Esme Pearl and Frank Bly's father, or the grandchildren of Mr. Larry Holderman, or issue either for the purposes of the anti-lapse statute. So, if we're given full faith and credit to the orders that were entered in the state of Washington to the adoption, then that just takes them out. So that's kind of my position on that, Your Honor. But it further goes to the intent of Larry Holderman, the testator, as to whether or not he wanted to include these people. And the facts that I was given by my client, or I should say that the history, is that Mr. Holderman, after the adoption, never saw, well, I should say, as I set out in my pleading, only saw Frank Bly one time in his life after the adoption, and only saw Esme Pearl twice in his life after the adoption, and only saw the grandchildren that were born at that time once during his entire life. So when you take that type of information into, you know, looking at, well, what was the testator's intent, I think that this information is very important for the court, because the court, under the case law that I've presented here, says that the court, in interpreting the will, needs to place itself in the position of the testator as closely as it can. So in order to do that, the court needs to know, you know what the kind of the family dynamic was at that time. And so I felt that the case law that I've provided does point the court, you know, in that direction. And once you do that, Your Honor, then you can look at the facts and easily, in my opinion, determine that Mr. Holderman's intent was to disinherit his children, which is absolutely set out in the will. I mean, there's just absolutely no other way to interpret the will.
Let's talk about that for a second, Mr. Mills. If
Okay.
earlier you were arguing that he was relying on Washington law that would apparently, under their statutes, automatically disinherit adopted children, then why did he mention them specifically in his Kansas will?
You know, Your Honor, I think
if he was relying on it, he wouldn't consider them at all, would he?
No, and here's what I'm saying, Judge. This is a very good point that I think you're making, and I think I have the answer. Because, Your Honor, I think all of the attorneys were not aware of this situation. And certainly I wasn't. I can't speak for the other attorneys, but I was not aware of this adoption until I just, you know, got to looking at Mr. Bly's name, and I kept thinking, why in the world is his last name Bly? So I called my client, and then that's when, for the first time, I figured out about this adoption, and I wanted to bring that information to the court. I think that maybe what happened was when Mr. Bly went to have the will signed, the attorney said, well, do you have any children? And he may have said, well, I had some children out in Washington, and maybe he didn't tell them that they were adopted, just as we've had a kind of a problem here with getting that information to all counsel. So I can see where I know if I had heard something like that, I'd say, well, let's just make sure we disinherit them anyway, just to kind of cover all bases. And so I think that's probably what happened there. And I think the fact that we've, been involved in this situation for quite some time, or this place for some time, and no one brought up the fact that these children were adopted, kind of speaks to that very issue.
All right. So, Mr. Mills, let me ask you this question first. Your client, Mandolin Holderman, is not mentioned as a beneficiary under this will. Would you agree?
I would agree, Your Honor.
So why is she entitled to anything under this will if she's not specific?
Well, I think what you have to do, Your Honor, is you have to look back at the facts and understand where Mr. Holderman was in his life and what had happened.
Okay, put that aside. Put that aside, Mr. Mills. I don't need an exploration of what he might have been thinking about. I just want to know, as a matter of law, why are you taking a position that your client's entitled to anything under this will?
Anti-lapse statute, Your Honor.
59-615?
Yes, clearly
which says what? Summarize it for me. What does it say?
It basically says, Your Honor, that when a relative who is the named beneficiary or devisee, when they are named in the will to receive, and they predecease the testator, but they leave surviving issue, then in that event, those surviving issue will take what the deceased beneficiary would have taken. And so there's no dispute that my client is a issue of these grandparents. And so she would take what the beneficiaries who were deceased would have taken. And so
All right.
there's no question about that.
All right.
The question,
Okay.
go ahead.
Thank you, Mr. Mills. I appreciate the summary explanation of the Kansas anti-lapse statute. We'll be getting back to that. So, did you have any other presentation or argument that you wish to make at this time?
Well, Your Honor, I would just refer the court back to my brief that I think, well, it's not brief, but I mean my pleading that I think goes through the law pretty clearly, and I will say I understand it, that the court and counsel got it maybe a little bit untimely, but it certainly I did the best that I could to get the law to the court, and I think if the court reviews it, it will have the law that it needs to reach its determination.
Thank you, Mr. Mills. Mr. Cranmer.
Thank you.
Thank you, Your Honor. I did receive Mr. Mills' pleading, however, I think it was filed around noon or so yesterday.
What they keep referring to about Mr. Mills' filing is back on 7/7 when their prior hearing took place, apparently Judge Rickey ordered Mr. Mills to write something up regarding the anti-lapse statute and how it applied in this case. And he did not submit it until yesterday, middle of the day, which meant most of the attorneys did not get it till last night. It was a multi-page filing with quite a few citations and a lot of information compiled into it. So obviously they haven't had time to fully review it, to prepare any kind of answer for it. So they're all a little upset that they received this at the last minute when he had a month and a half at least to prepare it.
I had court yesterday afternoon, so unfortunately I didn't get it forwarded out to my clients until last evening. They have told me this morning, and they had sent me an email, I haven't spoken to them, that they were not adopted. It is true that Mr. Holder and the decedent and the Frank and Pearl's mother were divorced, and she remarried to a man named Mr. Bly. I can't remember his name. I am told, and I asked my clients about this when the case first started, why was his name Bly? And that's when they explained to me that their mom had remarried to a man named Mr. Bly, and they had done a name change. And they specifically indicated at that time that it was not an adoption, it was a name change. And they reiterated that via email to me this morning, that they were not adopted. This was some sort of a name change action that took place up in Washington State, not an adoption.
Mr. Cranmer, under Kansas law, is that a difference that makes a difference? Aren't
I don't think it does make a difference.
adopted children still entitled to inherit from a natural parent in Kansas?
In Kansas, I believe they are, and that was kind of where I was leading into. I mean, the next Mr. Mills' pleading then goes into talking about Alabama law and Arkansas law and things like that. Well, I don't believe that's the law of the state of Kansas. I believe an adoption does not cut off the right to inherit unless it specifically says so. And again, I didn't have a chance to look at the law up on that due to my late receipt of Mr. Mills' pleading. So I really don't think it makes a difference, but I just wanted the court to know that it's my understanding from my clients that they were not adopted, they just had a name change, and that's it. So I will just highly summarize our position, Judge, and of course I would welcome any questions you might have. But I think the case of Estate of Strobel, 6 Canap 2nd 955, it's a 1981 case, and the Kansas Supreme Court denied review of that in on January 20th of 1982. The Strobel case facts and the facts of this case are nearly identical.
To say the two cases is identical is a huge stretch, in my opinion. However, he doesn't really give you any background on the Strobel case, so let me tell you what it's about really quick because it's really interesting. So Miss Strobel was a Kansas woman back in 1978. She had kicked her husband out, was in the process of getting a divorce. She moved her mom in and her mom was living with her. She did what she was supposed to do. She revised her will. She said, I want to leave everything to my mother as long as she survives me by 30 days, and I don't want my husband to get anything. Somehow, she left her car running in the garage of the home that she shared with her mother. Both her and her mother died of asphyxiation and carbon monoxide poisoning. This is where a legal battle ensued over her will. Her husband thought he was entitled to everything, and there was no backup beneficiary listed. There were two provisions of her will that caused an issue. It was her mother had to survive her by 30 days, and her specifically eliminating her husband. This basically eliminated any of the family heirs from inheriting her estate. To overly simplify the conclusion, she basically wasn't able to exclude her husband from her inheriting in her will because she didn't have anyone else to leave her property to.
In that case, the Strobel attempted to disinherit a relative. In that case, it was her husband. In this case, the decedent attempted to disinherit his children, Frank and Pearl. In Strobel, the intended beneficiary, who was in that case the decedent's mother, did not survive the decedent. Well, the same thing happened here. In this case, the intended beneficiaries, who were the decedent's parents, predeceased the defendant. So in the Strobel case, the will did not contain a residuary clause. In this case, the will did not contain a residuary clause. In Strobel, it was found that a decedent cannot disinherit his heirs by words alone. So in order to disinherit his heirs, the property must be given to somebody else. And it wasn't. There was no residuary clause. That was it. That's the same thing that's happened here. The property has not been given to anybody. The gift away from the purported disinherited people has not been completed. And that was found to be not a good disinheritance. In Strobel, it was found that where a bequest lapses because of the death of the beneficiary prior to the death of the decedent, and there's no residuary clause in the will, the property subject to the lapse bequest passes under the laws of distribution as intestate property. And we believe that's exactly what the court should find in this case. It's exactly the same thing. And therefore, the anti-lapse statute does not apply to property that passes via intestate succession or under the laws of descent and distribution.
Okay, Mr. Kramer, let me stop you there. What precondition did Franklin and Clara, the primary beneficiaries under this will, what condition did they fail to meet?
They didn't well, it's implied that they need to survive the decedent in order to be able to take his under the will.
But isn't that exactly where the Kansas anti-lapse statute is intended to step in?
But
Strobel, it would seem to the court that Strobel's different in that case, the primary beneficiaries had to meet a condition, which was a survival condition. That language does not exist in this will. Doesn't that make Strobel factually distinguishable from this current case? You say they're exactly the same, or you're suggesting they're exactly the same, but the reason why there was a lapse in Strobel is because the precondition wasn't met. There was no precondition here. And while it's true that Franklin and Clara didn't survive the testator in this case, that's not an unusual situation. The legislature's contemplated it and passed a statute that steps in, does it not, and say, well, if there's any lineal descendants, there's no lapse. Isn't that true?
But again, I think that's a distinction without a difference, because I think the implied condition is that they have to survive the decedent in order to take under his or her will.
Well, if that's true, then the anti-lapse statute has no meaning at all.
Well, it goes by.
Mr. Mills has consistently argued from the beginning here.
I think that it under Strobel, the will failed. So therefore the anti-lapse statute
Okay.
never
Right,
applied.
so let me ask you, how did the will fail here? Yes, the testator in this case, for whatever reason, left his estate to some people much older than him. It's certainly possible that somebody older than you isn't going to survive you. But that those individuals that received the benefits of this will left issue. So isn't that exactly a Kansas anti-lapse statute situation?
But because the gift was not completed, in other words, there was no residuary clause to apply, it passes outside the will through intestate succession. That's why I say the anti-lapse statute does not apply in this case.
All right.
I'll,
All right. I
I'll
understand your
Strobel.
position. Okay. All right. And if that's the case, then who would be the beneficiaries of this will, or who would receive this estate is the better question. Who would be the ultimate beneficiaries of this estate if the court accepts your argument, Mr. Cranmer?
It would be my clients, Frank Bly and Esme Pearl.
Okay.
And that was the same way it was in Strobel. And the other case I'm relying on is In re Estate of Hainberg, and that's 270 Kansas 365. And again, that's another case. It's not, there was not an attempt to disinherit anybody, but there was no residuary clause in the will or the codicil to the will, and give to an heir lapse in that case, and it was deemed to pass under the laws of intestate succession, not under the anti-lapse statute under anti-lapse.
All right.
Those are the two cases, and I would point out that the two cases I'm relying on for the most part are more recent cases than any case that anybody else in this case is relying on, and they still remain good law in Kansas. I think the court's pretty familiar with the rest of my arguments from last time, so I just wanted to summarize everything for you. If
Thank
have
you
any
for your
questions-
concise
if you have any
summary.
questions, Your Honor,
I understand your position today. Ms. Williams, what position do you take here?
Yes, Your Honor. I did a great deal of case research, and my understanding of the question that the court was contemplating was basically if, when applying the anti-lapse statute, if we could do a generation skip and skip over Frank and Esme Pearl, who otherwise would have been beneficiaries but were disinherited. I can tell you there is no case law out there. As far as I can tell, nothing in Kansas, nothing in any other state, just simply nothing on point. What I did start realizing as I'm researching, there is a definite theme, and that is a disinherited person can inherit through intestacy. If intestacy applies to a situation, then that's when the disinherited person can come back in. But where the anti-lapse statute is being applied, I saw nothing where they were able to skip a generation over a disinherited generation and go to their issue. So I very much disagree with Mr. Cranmer's interpretation of Strobel. I think his interpretation would do away with the anti-lapse statute altogether. This is not a case where intestacy law should be applied. It's an anti-lapse statute. My client and Mr. Mills's client would be the grandchildren of the two original beneficiaries. Since neither of those
Is that conclusive at this point factually?
not,
Do you have documentation?
it is still a disputed fact that we're going to have to take up, Your Honor. And I don't know if you want me to get into that now, because that's a whole nother conversation of where we are on that.
No, not particularly, because
Okay. Yes, but that is something that we're still working on. Yes, but we believe that my client will be one of two heirs. I don't believe that just because the two original beneficiaries are deceased, that somehow we can apply the law to bring in those two disinherited grandchildren, Frank and Pearl. To get to their children, you'd have to generation skip, and there is nothing that I can find in any case law or statute Kansas or otherwise, that would allow for that. And that is the distinction I started realizing that I was seeing, that I couldn't find a fact pattern such as the one before us. But all the fact patterns where a disinherited person was brought back in was under the laws of intestacy. So I think that is a significant distinction. I think also where you have the anti-lapse and where you have disinherited folks, the testator's intention has to be supreme. Now, I don't know if they were, if Frank and Pearl were actually adopted or not in the state of Washington. That obviously makes a difference. If they were adopted, though, I do think, even though this is a Kansas case, the Washington statute under which they were adopted says that, unlike Kansas, you don't inherit from your biological family once that happens. And I think that law would dictate if they were heirs or not, if they were considered legal relatives of Mr. Holderman anymore. However, it sounds like that is in dispute. Even if they were not adopted, I still don't believe under anti-lapse that they can come back in to the into the will as beneficiaries, because they were clearly disinherited, which is allowable. And I believe Mr. Holderman did exactly what he had to do to disinherit them. So I don't believe we can revive their standing. And I think because we can't revive their standing, and there are two other people in line to inherit, that we can generation skip and then bring in the great-grandchildren to inherit. So that is, I think, what I believe is that we have to apply the anti-lapse statute. And so it comes down to Mr. Mills' client, and I believe to my client at the end of the day.
All right. Thank you, Ms. Williams.
You're welcome, sir.
Mr. Weta, do you take any position here on the will construction issues before it?
Thank you, Your Honor. It's difficult for us to take a position at this point. We have my client has a fiduciary duty to the beneficiaries, and right now we're trying to figure out the beneficiaries. I will say that I think that there's been a lot of case law put here today. I spent some time with Mr. Mills's submission from yesterday, and I would beg to differ with his characterization that it pretty clearly lays out the law. I don't think there was anything clear about the pleading. It was remarkably difficult to get through because it was a mixture of both law and fact. And they call them uncontroverted facts, and I don't believe that those facts are uncontroverted in any way, shape, or form. And I think he admitted that today on the record when he rolled back his and said that it was family history instead of uncontroverted facts. To that end, Your Honor, our position remains that we will do what the court tells us is required to do. We do think that the court should apply 59-615. We do believe that this situation does apply to that circumstance. We disagree. My personal interpretation of the statutory language disagrees with the others who are asking to apply 59-615. 59-615 specifically states that if someone qualifies to receive the gift and predeceases and leaves issue, that issue should take, and that the issue of the individuals who were given there are, at least to the best of our knowledge, the four individuals that are put here in front of you: Frank, Esme, Joy's client, and Mr. Mills's clients. We think realistically that the grandchildren shouldn't take, but if the court were to interpret the statute to say that the disinheritance requested in the will still requires that Frank and Esme be disinherited, then I believe our position is still that looking at testator's intent, he did not make mention of any grandchildren or any issue of those two individuals in his disinheritance, and therefore the court cannot presume his intention. The court can only determine his intention from what was put down in the will itself. And so to that end, that is our position. But at the end of the day, my client is not a beneficiary of this estate, and frankly, just wants to ensure that she is complying with her fiduciary duties to all of the beneficiaries going forward. Thank you.
Thank you for your concise statement of position, Mr. Wetta. Court's prepared to rule on issues in this case at this time, and I do appreciate the time and effort by all the attorneys involved in this case to make their positions clear. This has been at least an interesting and fascinating exercise in the law for this court. For anyone who might be watching YouTube today and essentially participating in the public viewing of this public case, court wants to go over some basics in this case. The decedent, the person whose will is at issue here, is a fellow by the name of Larry Franklin Holderman. Larry Franklin Holderman did a will, I think in 1999, that contained a specific provision that he's leaving his estate to his parents, Franklin and Clara. In the third paragraph of that will, he makes it quite clear in the view of the court by stating, I am aware that I have two children, namely Terry Robertson, also referred to here as Esme Pearl, and Frank Bly, and it is my will that neither child inherit under my will. As might be expected, when interest in an estate is left to persons older than the person making the will, Frank and Clara both predeceased Larry. In other words, his parents died before he did. There is no residuary clause under the will. There's no contingent beneficiary. Quite frankly, if I had been advising that client, I would have tried to advise them that it would be important that if you're going to leave your primary estate to people older than you, especially a generation older than you, that you name contingent beneficiaries. But that wasn't done here. So the persons who were to receive under the will, and the only persons that are specifically named, were Frank and Clara. They both predeceased Larry. So what happens now? Well, what happens now in the view of the court is application of the Kansas anti-lapse statute, which has been referred to liberally during the course of this proceeding. This is a law passed by the legislature of the state of Kansas to prevent people from being declared intestate. In other words, it's to give effect to wills even when a primary beneficiary passes away. Kansas's law is just relatively simple and says, well, then their descendants, their lineal descendants, will take their place. Without it's being stated in a will, by operation of law, the anti-lapse statute applies. The court rules at this time that Mr. Cranmer's arguments regarding the in re estate of Strobel are not applicable to this case. Strobel is legally and factually distinguishable. In Strobel, the beneficiaries in that case had to meet a precondition before anybody took under that will. In other words, they had to survive the testator, as the court recalls, by 30 days. And they didn't do that in that case. Therefore, since they, the primary beneficiaries, would have never received anything under the will, no one under them would receive under that will either. Therefore, the Kansas anti-lapse statute did not apply in that instance, and the property passed through intestate succession. The will lapsed in the Strobel case. There is a quote, and a very appropriate quote, that Mr. Mills put in his brief that I'm going to repeat at this point. This was from the estate of Russell, a 1975 case, and I'll try to go slow. In construing a will, courts must, A, arrive at the intention of the testator from an examination of the whole instrument, if consistent with rules of law, giving every single provision thereof a practical operative effect. B, uphold it if possible. C, avoid any interpretation resulting in intestacy when possible. D, give supreme importance to the intention of the testator. And E, where the language found in such instrument is clearly and unequivocally expressed, determine the intent and purpose of the testator without resort to rules of judicial construction applicable to the interpretation of an instrument which is uncertain, indefinite, and ambiguous in its terms. This will can be upheld by the assistance of the Kansas anti-lapse statute, which is intended to apply in this situation. The court can give meaning and effect to all of this will's terms. In essence, what happened here is that the will left the property to Franklin and Clara, Larry's parents. They died first. The anti-lapse statute then comes into play. And the question then becomes, is there any person who was issued a Frank and Clara who survives, who can step into Frank and Clara's shoes? Well, the answer is clearly yes. Mandolin is a grandchild of Frank and Clara, the child of Dennis, which was a child of Frank and Clara. So she's a granddaughter. So clearly, there is surviving issue. So this is not a will that lapses because there's nobody to leave it to. The Kansas anti-lapse statutes intends that Mandolin steps into Frank and Clara's shoes. So the will can be carried out. Susan Davenport, if she can appropriately show paternity or parentage in this case, that she is linked to Frank and Clara as what would be a granddaughter in this instance, would also share in this estate. That is not clear. The court makes no ruling on that particular issue. Then the issue becomes, what about the children of Larry, which would be grandchildren of Frank and Clara? That would be Terry, Esma Pearl, whatever name we give her. She's one of those children. Frank is the other. To give effect to all provisions of the will, the court must look at the fact that Frank and Pearl were specifically, clearly, and unequivocally disinherited in this will. This court will not ignore the obvious intent of the testator, which took those two out. I am aware that I have two children, namely Terry Robertson and Frank Bly, and it is my will that neither child inherit under my will. He couldn't be more clear about their disinheritance. It is the ruling of the court that they do not come back in as a result of the anti-lapse statute, that to give effect to the will and its provisions, they are specifically disinherited because the will calls for that. And the anti-lapse statute makes it clear that that the court has to still follow specific provisions of the will when it comes to application of the anti-lapse statute. So the court rules that Pearl and Frank are out. However, this court also has to find that the language used in the will makes no mention of the issue or lineal descendants of Terry, Ezra Pearl, or Frank. And the court finds that it would have been really simple to add language to make that clear. For example, to state that my children and their issue are disinherited. My children and their lineal descendants are disinherited. My children and my grandchildren are specifically disinherited. But no such language appears. Mr. Mills would have this court simply imply that those are parts of the will. They are not. Those words are not there. This court cannot read them in. A language of disinheritance must be specific and clear as to the individual's disinherited. There is no clarity in this will that there was any intention to take out what the court would deem as innocent beneficiaries or innocent heirs who are not specifically disinherited. It does appear to the court that Pearl has 4 children. Am I right? 4? Victoria, Claire, Isaac, and Stuart.
That is correct, Your Honor. 4 children.
The court rules that those 4 would take what would otherwise be an appropriate share of this estate. Now, Victoria, Claire, Isaac, and Stuart are not grandchildren. This court views Frank and Pearl's disinheritance as legally dead. They are construed by this court to be predeceased when the court applies the anti-lapse statute. I hate to use the term, folks, but I think that it helps illustrate what happens in a situation like this. If indeed Pearl and Frank are legally dead, their children aren't. These children are not specifically disinherited. Therefore, they would take, the 4 children of Pearl would take and split their mother's share that she would have had she legally lived, which would be a granddaughter's share of either 1/2 or 1/3, depending on what comes out on the Susan Davenport situation. So it would be the court's ruling then that the children of Pearl are not specifically disinherited, and that they do take under the Kansas anti-lapse statutes as lineal descendants, not essentially of their parent, but of their great-grandparents, Frank and Clara. They haven't lost their status as great-grandchildren of the beneficiaries of this will, Frank and Clara. So I believe that the court's pronouncements this morning resolve most, if not all, issues in this case. The court directs the estate's attorney to carry out the court's ruling in regards to disposition of this particular estate. We still have a very important issue regarding the parentage of Susan Davenport. Obviously, if she is excluded, Mandolin would receive 1/2 of this estate. Victoria, Claire, Isaac, and Stuart, 12.5% in the view of the court. If Susan Davenport's included, then Mandolin would receive 1/3, Susan 1/3, and then the other kids would receive 1/12 of this estate. Mr. Mills, this court specifically rejects your argument that they have to file any type of claim or assert any type of entry into this proceeding to receive. Either they are beneficiaries under the will or they're not. Now, it very well may be appropriate for a number of reasons for them to disclaim their interest in this estate, but that has to be a voluntary act on their part. The estate's attorney would be directed to contact them and I suppose inquire as to what their intentions are regarding receipt or non-receipt of part of this estate. I suspect I know what their answer will be, but I think that's up to them. And obviously that would affect an ultimate outcome depending on what decisions they make. Mr. Webb, I'm curious, do you have viable addresses for each of these 4?
Yeah, we believe that we do. We have sent them notice of this hearing as well as notice of prior hearings, and my client is present with me in my office and says that she believes that she has accurate addresses.
All right.
And we will confirm that before we send it.
If there needs to be an inquiry, I would sure she should be able to provide each of her children's current addresses, I would hope. All right. So let me address Ms. Williams at this point. We have an ongoing issue, and it's an important one as to whether your client even shares in this estate or not. This court would have to have proof provided to it, unless there's a concession, which I've never understood that there is, that she is one of the children that would receive. She would be the child of John Kennan, which is Clara Holderman's son, and she has to prove that. And I got an impression from Mr. Mills' submission that the adoption records were inconclusive.
Actually, the adoption records were very interesting, Judge. Basically, we obtained the adoption file and we obtained my client's pre-adoption birth certificate. In the adoption They state that the father is unknown. They give no notice. They don't publish anything. But back then, they would have a social worker, looked like maybe a SRS social worker, do a little investigation, a little bit write-up. And for some reason, this unknown person, they had a birth year and they knew his occupation was that of a jockey in Eureka. So then we go to the birth certificate where the father's information should be, and this is the pre-adoption birth certificate. You would assume that there'd be no name or the word unknown or someone's name. It wasn't any of those three. It said not unknown. Not unknown. So this gives credence to what my client had always been told, was that there were a couple of things going on. Her mother, her biological mother's family, was rather embarrassed by this situation, felt like the biological father's family was of a different social class. And there was some embarrassment of that. And number two, there was an age difference. The mother was 17, the biological father was 21, and there were some threats that if he was named father, if it came out, that they might try to pursue getting him thrown into jail. So I think clearly they knew who the father was, but they did this shell game of pretending he didn't exist. Clearly they knew who he was. I have been working through trying to go from the least intrusive, least expensive ways of showing my clients paternity up to the more intrusive, more costly ways. I believe Mr. Wetta's client accepts my client as an heir. There is all kinds of family evidence, and including Mr. Mills's client has known my client since 1989, has met her several times, has called her cousin, but now doesn't once this has come up. There are pictures. My client was in the obituary. She is listed on the headstone as the daughter of Mr. Kennan. I realize that that is not DNA evidence. The local.
Okay, let me ask, who made the decisions to include her in an obituary on a headstone? Who made those calls?
I can tell you, Mr. Holderman, Frank Holderman, and Mr. Kennan's mother, the grandmother, the paternal, biological paternal grandmother.
Clara?
Yes, yes, sir. We've got pictures of the headstone listing her as daughter, the obituary listing her as daughter. Mr. Kennan acknowledged her as daughter. We have pictures of the family. I mean, everyone accepted that she was Mr. Kennan's daughter, including Mr. Kennan and Mr. Kennan's mother, who was an original heir to this will.
Well, apparently not everyone has accepted
Well,
that.
not everyone. Ms. Holderman is now not accepting that. So basically, I have looked at local, like utility consultants and their DNA. Do you want me to get into this at this time, Judge?
Well, your presentation's been excellent, and I understand now that you have a good faith factual basis to make.
Oh, absolutely. Yes, absolutely.
It does appear that there may need to be a trial on the merits on this issue if it's contested. I trust that you're going to provide any and all documentary evidence to the other attorneys involved in this case, particularly Mr. Wetta, Mr. Mills. I'm not sure
Absolutely.
exactly what interest Mr. Cranmer is going to have after today. But obviously, if he asks for that information to be shared with him, I will require it. And then if the parties are unable to reach an agreement on that issue, then it'll need to be set for trial, frankly. Where the
Okay.
burden of proof will be on you and your client to prove that she is a lineal descendant of Frank and Clara.
And well, yes, I think you're right. We're exploring the DNA possibilities, which starts getting us into the weeds a little bit. We can address that later, but yes, Judge, we are working through the steps, trying to go from least to most intrusive to try to figure this out.
Like exhuming a body.
Yes, Judge, that is what I'm getting to. Yes.
There's no other known source of DNA.
Yes, there is. And that's why I didn't know if you wanted me to continue. Let me tell you that first I tried like utility consultants, a local agency that does DNA testing. Their tests are aimed to determine paternity. Therefore, they are not the most sensitive of tests. So if we had the putative father or the putative father's brother, something like that, we could use that. But in this case, all of that generation is deceased. We have like a great uncle, we may have a great aunt, we may have a cousin. So that's part of our problem. So then I think it comes down to either we use a site, a professional site such as ancestry.com or one of those type sites that has a much more sensitive test that can genetically link you with even your fourth cousins, and we accept that, or we start exhuming a body. And I hate to go there, but that would be the possibility that we exhume Mr. Kennan. Mr. Holderman, the gentleman whose will we've been dealing with, was cremated. My understanding is cremains can be tested. However, it is unlikely that they will give us a good result unless there's a great deal of bone marrow that survived the process. So it's unlikely that that would be a good source. So either we agree on a commercial testing site like I have described, or we look at exhuming Mr. Kennan. I've been trying to avoid that eventuality, Judge.
Mr. Weta, I presume that the estate's inventory has been filed in this case?
Yes, I believe it has, Your Honor.
Just trying to look at the financial viability of
I've
been discussed, and I see that there are substantial assets in this estate. And
if I may interject, I don't mean to throw too much on. I think Joy has done an excellent job of presenting her client's case at this point. But it is my understanding from our construction of the family tree that Mr. Kennan is related to Clara only.
yes,
And I do think that will change our mathematics if she is indeed a beneficiary, given that she would only be entitled to half of the estate that would go to Clara through chapter 59-615, as she was not a lineal descendant of Franklin. So I do think that it would slightly change the mathematics, but I think we can get to that point if her client is able to show the evidence necessary to either by agreement or by trial, Your Honor.
and of course, I encourage the family to reach a family settlement agreement on these issues, if at all possible. But further discussions need to be held based on today's rulings of the court regarding the contested issues which are currently before it. So from here, Ms. Williams, how much time do you need? I think that Mr. Weta at some point would like to close this estate. I trust claim period is run, that the case might otherwise be in a position for final settlement if we can get these issues resolved. So what are you proposing here, Ms. Williams?
If we agree on using a commercial DNA website, it would take a few weeks to get the results back, but it would be, I would say 6 weeks, 6 to 8 weeks. If we are talking about exhuming Mr. Kennan, then that we would have to get the proper order to do that, exhume him. But then once we get the sample, it's a matter of getting it tested. I think maybe one of the more local testing sites could do it at that point, because then it's a paternity test, not trying to connect more far-flung relatives to each other. But we're talking a matter of probably a couple months.
All right, coordination of this many attorneys is problematic. So while I have everybody on this meeting, I'm going to have my assistant propose a date for status review. I'll allow an hour for this hearing. If there's some relatively quick and concise issue that the court can resolve, perhaps I can do it on that date. But I want to at least review the status. I don't want this case just to float off without any deadlines or court review. I'm looking at the last week of October, Mandy. Can you propose a date for an hour setting in the last week of October, and then we'll see if we can get it coordinated?
We are open the 30th.
All right, October 30, counsel?
Yes.
That works for me, Your Honor.
Your Honor, I don't, as you noted, I don't know how much involvement I'll have, but I have a trial down in Winfield on the 30th.
Okay. Court has made a final ruling regarding your clients and your clients' interests. If your trial goes off, I certainly invite your participation, but I think I'm going to go ahead, if that works for all the other attorneys, I think I'm going to go ahead and set it there. Certainly, if you need to have an attorney substitute just to weigh in on what the status of the case is, that's certainly appropriate, Mr. Cranmer, but I'm going to go ahead and look for a date on the 30th.
That's
Okay.
fine, Judge. I just wanted to let you know, and I can probably have Sam or somebody cover for me on that. I don't think I can take any action with regard to an appeal anyway until the whole case has been resolved. I'll need to research that and I'll need to talk to my clients, but
Okay, did I get clearance from Mills and Joy
Yes, Your
Williams
Honor.
and
The
Mr.
30th,
Wetta?
Your Honor, the 30th is good for me.
Okay, Mr.
Your
Wetta?
Honor- Oh, sorry.
Yeah, I'm sorry, Your Honor. Did you say what time on the 30th?
I was going to propose 10 a.m.
That's fine for me. Thank you, Your Honor.
Your Honor, I have a standing court appointment on Monday mornings. I'm usually not done until 11 or 11:30. So I don't know that I can make 10 o'clock work. I'm
Are
sorry.
you free up in the afternoon then?
Later in the afternoon, I could do probably a 3:30 or a 4.
Okay. 4 o'clock work for you, Mr. Mills?
Yes, Your Honor.
Mr. Wetta?
I'm available, Your Honor. Thank you.
October 30, 4 o'clock p.m., the court will set a status review. I'm going to primarily be reviewing the issue of parentage of Ms. Williams' client at that time. October 30th, 4 o'clock.
Your Honor, that's just a status conference, is that correct?
Yes.
Thank you, Your Honor.
Perhaps it'll be an announcement of the settlement that's been reached by the family in this case. Certainly agreeable with the court if that's what it's used for. October 30, 4 o'clock p.m. status review. I'm not necessarily interested, Mr. Wetta, in determining all proportions because that's undecided for any number of reasons. But if the basic rulings that were made here today, I'm going to assign you the responsibility of drafting it. You are essentially more or less a neutral party. As the attorney for the estate, I'm going to task you with drafting an order stemming from today regarding the various rulings that have been made by the court today. If you'll circulate that among all counsel.
Yes, Your Honor. Thank you.
Okay. Thank you, Mr. Wetta. Greatly appreciated. Some reference to exact proportions that the heirs would receive under this order is yet to be determined, or something along those lines would be adequate. All right. Mr. Cranmer, anything further we need to address today?
I have nothing further for today, Your Honor. Thank you.
Ms. Williams, anything further at this time?
No, Your Honor.
Mr. Mills?
No, Your Honor.
Okay. And Mr. Webb?
Nothing further, Your Honor. Thank you.
Very well. Thank you all for your involvement and the quality of your submissions to the court and arguments made here today. If there's nothing further, the Holderman matter will currently be in recess. And Mandy, you may end this meeting for all at this time.
We previously met the Holderman heirs back in August in this case, and if you haven't watched it, I highly suggest you watch that first. This is a super complicated estate case, and Judge Ricky explained it incredibly well back then, and I also broke down the law and who everybody is, because there is a lot of players in this case. So this is an update to the case.
The Court of Butler County, Kansas, case entitled, in the matter of the estate of Larry Franklin Holderman, deceased. It's case number 2022 PR 168. Trent Wetta appears as counsel for the personal representative of the estate. Doug Cranmer appears. Who are all of your clients at this stage, Mr. Cranmer?
I still represent Frank Bly and Terry Robertson, who goes by Esme Pearl.
All right. Mr. Mills, I take that you still represent Mandolin Holderman. Is that correct?
That's correct, Your Honor.
All right. And Ms. Williams, you're still representing Susan Davenport. Is that correct?
That is correct, Judge, and she is with me today.
All right. Mr. Weta, I'm going to start with you. I did receive from you an order, which I think is submitted under Rule 170, that you drafted stemming from the August 22nd proceedings that we had. It appears to be consistent with the court's notes in all material respects. I'll just tell you just a brief summary of what I ruled on that date. The will can be upheld. Court will enforce the disinheritance clause, anti-lapse statute triggered. Mandolin Holderman and possibly Susan Davenport take from the parent beneficiaries named in the will. But Pearl's children, and I put 4 in parentheses, also received from the great grandparents, Susan Davenport's familial heritage, a disputed issue to be determined. Status hearing set for October 30th at 4:00 p.m. to review Susan's heritage status and to schedule further trial on issue as is necessary. Trent Weta to draft journal entry with proportions of the estate and the shares to be determined later. Now, Mr. Weta's order appears to be consistent with my notes in all material respects. I'm a little curious why I don't have signatures from all the attorneys. What's the problem here, Mr. Weta?
Your Honor, I submitted that order. I did also attempt to, I hope it came through in fax filing. I'm going to be honest. It's been since the very beginning of my career since I fax filed something, but I did submit alongside the Rule 170 notice objections that were put forth by Mr. Mills. I believe Ms. Williams also had a slight objection, but we addressed all of that in the second draft. All of those documents are there in front of you, just out of an abundance of making sure that the court had everything that was in front of it. But frankly, I believe the only outstanding objection was from Mr. Mills. And so I did submit that order, Rule 170, at that point for the court to determine today.
Okay, I know some of you are stubborn and didn't go back and watch the original. So real quick, Larry Holderman is right there on the second line over to the left. He's the one who was deceased. He left his entire estate to his parents up at the top, who are also deceased. And then the next people in line to inherit his estate would be his 3 brothers, who were also deceased. He didn't update his will, even though they died all before him. His 2 children, he specifically disinherited from his will. One of his children has 4 children. So the argument was, would the grandchildren inherit from his estate? And the answer was no. However, the grandchildren would be direct decedents, inheritance heirs from his parents who inherited from him. So the inheritance would jump over to the grandparents, then it would go down to their children, which there aren't any. Then it would go down to their children's children, which would be the 2 nieces and his 2 children, which were disinherited. Then their share would go down to the grandchildren. So the 2 nieces and the grandchildren. Well, the one niece, Mandolin, thinks she should get everything, and that's who Mr. Mills represents, and that's where this whole argument is coming from, is he is challenging everything because Mandolin thinks she should get the entire estate, which is valued at, I think, $750,000 last I checked.
Mr. Mills, the court's inclined to approve it in its current form. Your position on that?
Your Honor, the only thing that I wanted to make absolutely clear is that my objections to the portions of your decision that you made were clear. And I thought that it might be better to state something to the effect that you entered this order and that I objected thereto, so it'd be right in the order. All the other counsel believed that, hey, I'm worrying too much about that. It's already in the transcript or in the record, and so they feel, and they may be right, Your Honor. I just want to throw that out there, but out of an abundance of caution, I want to make sure that I'm not foregoing any objection by going along with the order as written. That's all it really is. I'm not accusing anybody of not trying to follow your order, Your Honor. I'm just trying to be very careful in my asserting my objection.
Well, your continuing objections are noted, but don't need to be chronicled in the journal entry stemming from August 22nd. I would agree with Mr. Wetta's position in that regard. The court will approve the order in its current form. That should be on file later today, counsel. And I'm going to ask the clerk's office that when they get the chance, they're a little bit overburdened at the moment, dealing with paper filings and the like. But when they can, I'll have the probate clerk mail a copy of this signed order to each of you at the address stated in the order. All right, with that done, I will move to the petition filed by Mr. Mills to deem request for admissions deemed admitted. It's relatively straightforward. Ms. Williams, I'm surprised that you didn't comply with the request for discovery in this case and didn't file a proper response within the time period allowed, at least according to Mr. Mills. Your explanation for that?
Your Honor, actually, I did. I sent my answers to him and I sent a notice to the court that I had so submitted those answers. I was never informed by Mr. Mills that he was still waiting for the answers. I sent to Ms. Stapleton today a copy of my email and my answers that show on October 16th. I sent them to Russell Mills by email. And the first notice I had that Mr. Mills didn't get them was today when I got the email from Mr. Mills. I didn't know there was a problem. Had I been informed, I would have endeavored to get him another copy or fix whatever the issue was. But no, sir, we answered and we got them and I sent them to him. I was not aware that Mr. Mills didn't get them. And I'm not sure why Mr. Mills didn't get them because, I mean, you will see from my email that it was addressed to Mr. Mills.
What date did you send it?
October 16th, Your Honor. That was a Monday.
Okay.
I think the due date fell on the weekend, so we
Yes.
got them out on Monday, but we
All right.
got them out timely and they were answered. I've resent them to Mr. Mills, like I said, and Mr. Mills had picked up the phone and let me know we could have cured this, but no, sir, we endeavored to answer these in a timely manner.
All right. Well, I'm curious, Ms. Williams, since it is relatively pertinent to the issue, primary issue we have left. How many of these proposed requests for admissions did your client deny?
Haven't counted, Your Honor. There were several that she put don't know on. She actually, well, she denied outright one, and there were several she put don't know on because she just simply didn't feel like she had the information. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, she put don't know because she wasn't positive of the answer one way or the other.
Okay, which one did she outright deny?
Number 7, they were asking about an adoption entitled matter of the person, their person of baby Cons, a minor, filed in 1968. If those records have been submitted to the court. And so she denied that one. That was confusing question.
All right, I think he's just asking whether the records from that adoption proceeding had been reviewed by you, Ms. Williams, but hadn't been filed as exhibits in the district court.
Yeah, if they're talking about her adoption, that is correct. Her adoption, I think the probate, I'd have to look. I think it may have been 67, but it was confusing. But yes, I've reviewed those that file. That is true. So to the extent that that matters, yes, I have reviewed that file. I think we know that. I've talked about that before with the court. So yes.
Okay. All right.
Your Honor, could I respond?
Yes, Mr. Mills.
Well, Your Honor, the thing that I would like to point out, and I don't mean to argue with counsel, but as I recall, I had sent those out to her on like September the 15th, and she had 30 days to respond, and October the 16th would be past the 15 days.
Doesn't she
So-
get the benefit of the 30th day following on a weekend, Mr. Mills?
Well,
I mean, I traditionally don't work Sundays. I
well,
doubt if you do, though there are times when all lawyers seem to be pressed into service on Sundays. But I think, doesn't the Kansas Rules of Civil Procedure contemplate still that if the final day of a period falls on a Saturday, Sunday, or legal holiday, it's the next business day in which they become due? And that's what she says she did. She sent them on that next business day, which would make them
Okay.
timely.
I see what you're saying. Okay. I didn't receive them, Your Honor. I wanted to tell you why I didn't receive them. I don't know, but I didn't. So if that's a problem with the email, it's a problem with the email. But the other thing I'd like to say is, Your Honor, I'm not sure that you can enter a I don't know answer to a request for reduction. You can deny it and say why you deny it, and then that's fair. But I don't think there's a basis to allege a don't know. And since that's the case, then all those should be deemed admitted, in my opinion.
Well, Your Honor, I would suggest then we call them denied then, because she was trying to give what she felt was an accurate answer to the request for admissions. They're certainly not admitted. So if we need to go back and do a supplemental response, we can and deny all of those, but we're not admitting them because she didn't feel like she had enough information to say for certain if they were yes or no. So.
Which is a standard response under some limited circumstances. I suppose what's bothersome is that she did that with so many of these.
Well, you have to look at some of the questions. He's asking her things that she doesn't really know. I mean, no co-workers of John Kennan have ever appeared and stated that John Kennan spoke of having a daughter. She doesn't know if any co-workers have ever talked of him having a daughter. Mandolin Holderman never heard John Kennan speak of having a daughter. She doesn't know what Mandolin Holderman heard or didn't hear, except some of it's the questions asked.
Your Honor, if I could respond, the point of many of these requests for admissions is to determine what she knows regarding the answer. And if she doesn't know, then that means she's not going to be presenting any evidence in that regard, it appears to me. And if that's what they're saying, then I'm okay with those answers.
Begging the question, Mr. Mills, even if all of this were to be admitted, where would that leave us?
Well, that would leave us with a inability for, which I don't think they have anyway, but would leave them with an inability to establish any basis for establishing the child to be, meaning Susan Holderman, to be a child of the deceased John Kennan. And that's because she cannot establish that he notoriously had, that there's any evidence to establish that he notoriously recognized the child as his. And therefore cannot.
That is a pertinent point, Mr. Mills, and I think it may go toward whether there's any statutory presumption.
The Kansas statute regarding the presumption of paternity is mentioned quite a bit during this hearing, but it's not discussed enough that you can actually define it. So just to give you a brief overview, a man is presumed to be the father of a child if the man and the mother are married before the child's born, attempt to marry before or after the child's born, get married after the child's born, or the man acknowledges the paternity of the child in writing. The mother has the man's consent to put the name on the birth certificate. The man notoriously or in writing recognizes paternity of the child, including but not limited to a voluntary acknowledgement made in accordance with KSA 2012 supplement. Genetic testing, but it has to have a probability of 97% or greater. And the man has a duty to support the child under the order of support, regardless of whether the man has ever been married to the mother or not. And that is what is listed in this statute. So the two things that they're relying on is genetic testing, hopefully not, or the man notoriously or in writing recognizes the paternity of the child. However, that's really hard. You got to find something that shows that, defined notoriously, because the man's dead.
Of paternity here. It wouldn't appear to the court that there is.
Right.
I'm not sure that's ever even been asserted by Ms. Davenport, that there's one of the statutory presumptions of paternity which apply in this case. I think her position all along has simply been, I am a biological daughter.
Well, and
without any of the statutory presumptions being in place, shifting, I think, the burden of proving paternity to her, essentially through probably the one conclusive way to determine it, and that would be genetic testing.
well,
There's also some other proof that could be provided, but it wouldn't establish a statutory presumption, I don't think. Do you disagree, Ms. Williams?
Well, Your Honor, I'm wondering, I emailed my response to Mr. Mills' motion or petition to dismiss my client's claim with a proffer of proof. And once again, I emailed that to Mr. Mills, I emailed that to other counsel, and I sent a copy to Ms. Stapleton for your benefit. And I've mailed a copy to the court for filing. In that, we respond to Mr. Mills's petition, citing the case law that is relevant, and we proffer the proof of people who can come in and testify that Mr. Kennan identified himself as Susan Davenport's father. And so we have that information here. And once again, that was sent to Mr. Mills and to everyone else by email. And I guess I'd ask everyone if they got it. If not, I can resend it.
Mr. Wetter, did you receive this?
I did receive it and I have reviewed it, Your Honor.
Mr. Kramer, did you?
I received it, Your Honor.
Mr. Mills?
yes, I did, Your Honor.
Okay.
Okay. All right, Ms. Williams, what is what is this burden of proof here, the standard of proof that would apply to this?
The standard of proof, when you have an illegitimate child, basically comes, if you look at the cases that actually Mr. Mills also quotes in his motion to dismiss, Meyer v. Rogers and the matter of the state of Leicester case v. Dunlap. And it basically finds that a father can confer heirship or beneficiaryship for probate purposes on an illegitimate child by holding this person out as his child and that recognition of his paternity being notorious. And so these are the two cases that basically tell us that that is the way that one of the ways, other than our possible DNA evidence, is to show that she would be a beneficiary. So basically, if Mr. Kennan held her out as his child, and that recognition was notorious, or in other words, well-known, then he can confer the heirship or the beneficiaryship onto her. And that is what those two cases say. And we basically are attempting to give a proper proof here, showing that not only did he make these statements, but everyone in this orbit accepted it. And we've got several statements by family members and people who have heard, and at least one friend of Miss Kathleen Cox, which was her mother, who heard these things and are familiar with those facts. We also included his headstone and his obituary, which I think once again goes to the notoriety of his acceptance of paternity. He never questioned it, never told anyone he questioned it. He told people he was her father. Everyone accepted this. It was notoriously known that he accepted that he was her father and accepted that paternity. So, Your Honor, I think just with that, we meet the burden of proof in our case law. Now, we're also working on that DNA, which would also show that she's a biological child. But Your Honor, I think that what we've submitted to the court is enough right here with this response to Mr. Mills.
I think Mr. Mills has also raised a statutory defense. I think he's alleging, I hope I'm paraphrasing this properly, that your client's simply out of time under Kansas paternity law, understanding that the Kansas paternity statutes were passed after virtually all of these cases that you've cited were promulgated from the courts. And so if we look at what the statute currently reads, that you can bring in action at any time to determine the existence of a father and child relationship, which is presumed. And if it's not presumed until 3 years after the child reaches the age of majority. With all due respect, I think your client is more than 3 years past the age of majority.
Your Honor, I think that there are two different ways when you're talking about an illegitimate child who's been adopted by another family. Yes, if you had the paternity way where paternity was established, etc., that would be proof of his paternity. But you can also establish it by him notoriously holding her out as his child and that paternity being notoriously recognized. And so I believe there's actually two different ways. And so, no, I don't think my client is out of time. I don't think she has to go in and try to sue him to have some legal finding of paternity. I think that this, for probate purposes, is the other way that we can show it. Or a third way would be with DNA evidence. So no, I don't think she's out of time. I think it comes down is she a biological child, or has her beneficiaryship given to her by her father notoriously recognizing her as his child? So I disagree wholeheartedly with that analysis, Judge. I don't think going under the paternity statute is the only way when it comes to a probate case like this with an illegitimate child adopted by another family.
Your Honor, could I respond?
You may do so, Mr. Mills.
Thank you, Your Honor. Your Honor, the case law that I have cited and the counsel has just referenced were cases where I believe that the presumption of paternity under 2208 existed. Okay, it doesn't here, and so I would assert that the court is correct in its analysis of just being too late. When you look at 59501, just the definition, it talks about what children can be deemed children. Okay, well, a child who is biological and has been recognized as a child, so like my children, I recognize them from birth. My name's on the birth certificate. There's no question that I'm saying they're my children. So they are my biological children. Posthumous child, she wasn't a posthumous child. And children whose parentage has been determined under the Kansas law, parentage law. Those are the ways that you can be determined to be a child of the deceased, and none of those fit here. But Your Honor, just for the sake of argument, I would be willing to go through these cases and explain to the court that if the court, and I'll try and just cut to the chase, Your Honor, if the court would look at the case of Record versus Ellis, and I understand this is an old case, Your Honor, but I think it does help us. Okay, it's 97 Kansas, 754. It's a 1916 case. How it helps in this regard, Your Honor, is counsel seems to be hanging her hat on this fact of the father notoriously recognizing the child as his child. And in that opinion, and I'm kind of working backwards here, if the court wants me to work forwards to the back, I will, but I think that this Record versus Ellis case really explains what the issue that she's bringing out, meaning counsel for Susan Davenport's bringing out. And at page 756 of that opinion, it specifically states what is meant by the requirement of the recognition must be general and notorious. That's the issue she just stated. And the Supreme Court back then explained for us what that meant. And what it said, and it did refer to a bunch of opinions from the state of Iowa, because back then I don't think the state of Kansas had really clearly addressed this issue, but they did in this case. And what they said was, and if the court will allow me, just briefly read some of the decision. It says at page 757, the Supreme Court of Iowa, whose statute is identical with ours, has ruled that general means extensive, though not universal, and notorious is synonymous with open. It goes on to say, as defined by Webster, general means common to many, or the greatest number, widely spread, prevalent, extensive, though not universal. And notorious means generally known and talked of by the public, universally believed to be true, manifest to the world. It goes on and talks about yet another Iowa case. There's several Iowa cases that had interpreted this statute that was similar. And it says that there's a Watson versus Richardson Iowa case that it cites. And it says both of these words are used in the statute with the design of emphasizing the thought that the understanding of the father's recognition should be as extensive as the immediate community of his residence and within the common knowledge of the public. It goes on. Extensive, common to many, or the majority but not universal, not concealed, open, generally and commonly known or spoken of. Those are additional Iowa cases that the Kansas court is citing. And if you look at that opinion, you'll see that I'm reading it word for word. And this, Your Honor, frankly, kind of goes to counsel's side, which is the recognition required is not of heirship, but of sonship. This was a son in that case and not a daughter. It further, the court now in Record v. Ellis, our court, is saying the proof showed that the father frankly admitted the relationship when there was an occasion for him to speak and made no attempt to conceal the same, though it also appeared that there were many of his friends, relatives, and acquaintances who had no knowledge thereof. And if we look back at my request for admissions, Your Honor, you're going to see that that's exactly what we have here. In that case, the father visited the mother after the child was born. I'm talking about Record versus Ellis now. And actually sat on the bed and pulled the child in his arms and testified, or stated that this was his child. Now, going on in the Ellis opinion, it says, let's see.
Mr. Mills, if you back up a moment, the case cite on where the Iowa cases were cited defining notoriously or
Yes.
notorious.
Yes.
What's the cite for that?
The site, Your Honor, is
Yes.
it is I'm sorry, 97 Kansas 754. It's a 1916 case, but there are very few cases that define this. As a matter of fact, it's almost the only one I could find that specifically defined
Okay.
these words.
Ultimately, that may be helpful to the court, but I'm almost getting the impression, Mr. Mills, that you're making a closing argument following a trial in which Ms. Williams and her client have presented their evidence, and then you're trying to say it's insufficient to carry the day. I know that there's probably some incentive on behalf of your client to never let this go to court, but shouldn't she have the opportunity to prove that Mr. Kennan notoriously recognized paternity of the child?
Well, Your Honor, and I guess what I would submit to the court is, for the first time, I saw these affidavits that were submitted. But if you look at the affidavit, Your Honor, even the affidavit she submits, which appears to be the evidence she's wanting the court to look at to determine this issue of notoriety, even to try and get herself over the hump, they just don't make it as it relates to the legal definition that even if you believed everything to be true, it doesn't seem to me that you can get over this hump, because all of the affidavits that she obtained were not as required under the Record versus Ellis case. So I don't know what else she's going to be able to think she can bring to the table to establish this notoriety, but she didn't put it in any of these affidavits that, again, I just recently was able to see. And obviously didn't have any time to respond to, but I'm trying to do my best to let the court know what the law is, so the court can take a look at it. Now, these affidavits, Your Honor, I don't know if the court wants us to waste a bunch of time having a trial and have me cross-examine these witnesses to testify live, but I think if you don't get past the notoriety deal, you don't get past asking for a DNA sample. I mean, you've got to be able to show at least some foundation, evidentiary foundation that meets the statute, meets the case law, and it's not there. And again, I think the court was right in looking back at the paternity statute, because it's only when you have that presumption that you can even look at the paternity statute, and I mean,
Well, but they have a right to prove that one of the statutory presumptions exists. Do they not?
well, and Your Honor, if you look, what I'm trying to tell the court is, if you look at the request for admissions, that even now, some of them the court could look at and say, yeah, they're deemed admitted. But if you look at the affidavits, not that I'm saying that they should be considered evidence at this point, but if the court did consider them evidence at this point, they do not meet the burden of proof under the case law, to find this to be a child of Mr. Kennan. And so, Your Honor, I think she's just not meeting her burden, and it appears to me that she can't meet her burden, or she would have put much more into these affidavits. So,
Mr. Mills, are you representing to the court that there hasn't been any discussion of what the word notoriously means by our appellate courts for 107 years?
Well, Your Honor,
I think you cited a 1916 definition.
Your Honor, I understand.
And Mr. Mills, I'm much more worried about what the legislature meant when they placed in the KSA 232208, which apparently wasn't passed before 1985, what they meant by notoriously, which may or may not be the same definition that was used in 1916.
Yeah, Your Honor, the one thing, and I'm kind of with you on what you're saying. There is a case, and I just found it before, so I haven't been able to to, review it very clearly. So I want to make sure that's up front, but I'm certainly willing to share that with the court. Let me see if I can find where I wrote the site down. But there is a case called In Re Parentage of MF. That's 312 Kansas 322, a 2020 decision.
The court is somewhat familiar with that, Mr. Mills.
I'm sorry?
The court is somewhat familiar with that case.
Okay, so I wanted the court to be, aware of that. And I think that does go somewhat to, in fact, they talk about a timing element of the notorious representation or a writing showing that but as I understand it, that case is a little different in the facts because you had like a same-sex couple there. Now, whether that in and of itself affects the language of the statute or not, I'm not real certain because I'm just telling the court I haven't had the ability to look through that because I just found it today. So
well, I think that the trial this court was the trial court judge on that case, as I recall.
Oh, you may.
And there was a companion case that was decided at the same time where perhaps there was some more recent interpretation of the word notorious. I don't recall that being a specific point in the MF case, but I also note that the WL case that was issued at approximately the same time may have addressed it. So there may be some recent pronouncement from the court regarding what notorious means for purposes of the paternity statute. But be that as it may, I mean, there is perhaps another alternative here. This court could consider just exhuming Mr. Cannon's body. I presume it's buried somewhere and it wasn't cremated.
It's buried in Eureka, Judge, and he did have a traditional burial. So yes, that would be.
When did he pass away?
1976.
76?
96. 96. Yeah.
27 years ago.
Yes. And Your Honor, I will tell you.
Has anybody looked into the costs or the procedures that would be involved in exhuming the body for purposes of DNA testing?
Yes, Your Honor. And let me back up just a minute also to tell you that we have submitted Miss Davenport's DNA, and we had submitted one of her great uncles also. The great uncle DNA has not been tested yet, but we do believe that will give us a result. But also the exhumation would be about $5,000. It's in Eureka. I think that there'll have to be an order of the court, etc. But yes, I think we can get that done. And yes, we think that would be a good thing to do because we think that that's going to prove it. Your Honor, I'm kind of perplexed by Mr. Mills's argument. The things that he is saying about what general and notorious means. We have affidavits of Mr. Kennan telling people this is his daughter. I don't know how much more you can have. Then he's telling several different people, this is my daughter, I'm her father. I know
him acknowledging that in writing would be a statutory presumption creating event.
And at this point, we don't have it in writing. We have been looking. There were some letters. We're investigating as much as we can. There was a house fire. Yeah, there was a house fire, and we're afraid that they may have gone in the house fire, but we are looking for those. We have people who saw those letters, but unfortunately, we haven't been able to find one of the remaining letters. So we're investigating as much as we can. But Your Honor, you also have to understand that I don't know how we reconcile the fact that an adopted child can adopt through his or her biological family, even though they may be adopted by another family. So there has to be more than one path, not just paternity, but this other path of being held out generally and notoriously being their child. So I think through DNA evidence and or the testimony of quite a few different people about how he held himself out as her father and how it was known by everyone and no one doubted it. This was the fact that we can prove that she should be a beneficiary of this estate.
Your Honor, I'd like to respond to that.
You may,
Yeah.
Mr. Mills.
Thank you, Your Honor. The fact of the matter is I can go through the case law that counsel cites right now, if the court wants me to, and show the vast difference in what happened in the cases that she cites, and wherein the court in one of those cases found that the person was the child. In the other case, the court found that the person was not the child. But the facts are so different than what we're talking about. The other thing is that I think the court needs to be aware of all these statements that she's talking about. 4 of them do not even state that the deceased, Mr. Kennan, told them anything about the child as far as its birth or his paternity. The other ones are from Ms. Davenport's husband, her son, and her cousin, I believe, and maybe a sister-in-law. And they all supposedly stem from 1 week in the life of the deceased, Mr. Kennan, wherein supposedly he meets over at her house, meaning Susan Davenport's, and is purported to have made some statements. So 1 week out of 28 years, I think, after the child was born, supposedly establishes an open, obvious, notorious, all this other stuff that I say it does not, even if you adopt those statements as in some way accurate. But so, Your Honor, they don't even meet the burden.
Your Honor,
It's a situation, Your Honor, where you have the person who's here trying to get essentially an award of money from an estate, and what is she saying? My only proof is I say so, my husband says so, and my son say so, and my sister-in-law, and maybe 1 other person, and that's it. This doesn't meet the definition of notorious as set out in Ross.
Hasn't she been included in obituaries of the family as a daughter
yes,
of Mr.
Yes.
Kennan?
yes. And she's on his headstone too as his daughter, Judge. And it's a little more nuanced than what Mr. Mills is alleging.
Well, yeah.
If you want me to respond to that, I can. It's more nuanced than that. Basically, what he's referring to, several of his statements have to do with the fact that Mr. Kennan was when he had 2 weeks to live and he was released from prison. He spent those 2 weeks with his mother and with his daughter, Susan. And so some of these statements and these affidavits come from that time when he elected to spend the finite amount of time he had left on this earth with Susan Davenport, which you don't do unless that person is very close and very special to you. So yes, some of these statements are from then, but also statements are from prior to that, when the sister-in-law, the letters, the phone calls that she witnessed, and the affidavits that don't talk about specific statements made by John Kennan actually go to the notoriousness of his recognition of his paternity. So I think it is more nuanced than Mr. Mills is letting on. I also included copies of the front and back of Mr. Kennan's headstone, where she is listed as his daughter, and his obituary, which lists her as his daughter. So, Your Honor, I think Mr. Mills I think it's more nuanced than what he is talking about.
Who provided the information for the obituary?
His mother, Mr. Kennan's mother, my client's grandmother. And we also have, we've talked about that before. Clara Lodima Holderman, who was one of the original beneficiaries. And I think we had talked about that in an earlier hearing. And also, I know that there are pictures, we didn't include them in this filing, but pictures that Clara Lodima Holderman gave to my client of the family and people like that, all the things that she was sharing with her granddaughter, and I think she put on comments like, "This is your cousin," and things like that.
Letters saying who everybody was,
Yeah,
how we were related,
yeah,
who my dad was.
it's okay, it's okay. Yes, so Your Honor, that goes to the notoriousness of Mr. Kinnon accepting his paternity of Susan Davenport. So if we have an evidentiary hearing, we will bring in a whole line of people, including Stanley Cox, who used to be in the sheriff's department, who is her uncle, and tells you there is no doubt that she is John Kinnon's daughter, even though the Cox family was the one who really was very upset that John Kinnon was the father, because Mr. Kinnon was someone who was in and out of trouble with the law and was not of the same social status as their family. But they even admit, no, he was dad. And, he was a 9-year-old in the house listening to everyone talking and everything that was said, including statements by Clara Lodima and his sister. So, Your Honor, there is a whole story here. There's a whole reason to understand that why she has every reason to be that she is John Kinnon's daughter. I mean, that's what it comes down to.
Your Honor, I think we really need to, let the court know that when the mother of Ms. Davenport had the opportunity to be honest with the court, she was in the adoption case when she said father was unknown. And now we're coming here and we're trying to say that she wasn't being honest with the court, because she supposedly did know that John Kinnon was the father. So, which is the truth, Your Honor? I like to go with people who, take an oath and say, hey, look, I don't know who the father is. And if she was saying and I don't know that this is true or not, Your Honor, but if she did say that to somebody that this was him, the guy who fathered her child, there's no way we're going to be able to prove that. He's deceased and she's deceased, and so we're asking for people to override the representation that the mother made, that she didn't know who the father was.
Well, on the other hand, Mr. Mills, she also didn't say that someone else was the father.
Well, Your Honor, when you say
it's just an open book, a question that has never been answered. Ms. Williams and her client believe that they can determine that there was a known father in the case.
Yes.
You're not having to rebut a representation of the mother. She just said, I'm not going to put a father's name down. I'm going to say it's unknown. The court has experience that many women do put unknown on a birth certificate, even though they in fact do know who the father is, but they take that position because they don't want that particular individual named on the birth certificate. So I see your point that that's certainly not something that helps Ms. Davenport in her claim, but also it doesn't seem, in the view of the court, to hurt her much.
Well, Your Honor,
because it doesn't establish who the father is.
If I might say, the Rickaval case tells us that we cannot base an opinion on speculation or conjecture, and that's all we will have is speculation or conjecture as to that issue.
Yeah, yet to be determined, Mr. Mills. Counsel, Mr. Weta, let me address you.
Thank you.
This court is currently contemplating sending these parties to mediation in this case, to sit down with a mediator to see if there is some settlement that might be reached. Now, it would seem that the opposing parties that would need to be part of this mediation would be Mandolin Holderman and Susan Davenport. The other four aren't represented here. They haven't been actively involved in this case, even though the court has determined that they very well do have an interest. Nevertheless, they don't appear to be actively involved opposing Ms. Davenport. So rather than exhume bodies or have lengthy trials on this issue, isn't there some way, Mr. Weta, that we might be able to sit down? And of course, you would be a necessary component to the mediation because you represent the estate as a whole, and see if there isn't some way that this issue might be determined with the assistance of a mediator?
Frankly, Your Honor, I have no objection to attending a mediation with the parties. I will say, though, that frankly, it appears to me that Mandolin Holderman's position is she refuses to move off of that position. Mr. Mills has, frankly, in my opinion, filed multiple petitions out of time or out of order with the court to try and prevent Miss Williams' client from even putting on her case at a trial. And frankly, the answer to basically every single one of his questions and Miss Williams' client's questions is for us to have a trial or to exhume a body and have the DNA evidence and have the answer. So I have no problem going to mediation. I've been to mediation many times. Frankly, we will be a kind of quiet third party in that mediation. But you know, I disagree with Mr. Mills's interpretation of several of the cases, and frankly, the black letter law. And we'll be willing to share that. But for the most part, we're here as the representatives for the estate to try and just determine where we're supposed to write the checks at the end of this. And so, you know, the goal and our procedure, our goal here was to try and determine as much of this as possible through agreement before the initial petition to determine heirs was filed, during the normal process of final settlement when the court determines heirs. Obviously, that was preempted by the by Mr. Mills and Miss Holderman's petition, and so we're now trying to determine that. At this point, that's fine. We still need to know who the heirs are, and my position throughout this has been we have to give each individual the ability to present their evidence that they are an heir, because even a child who is adopted out at birth has to obviously be given the opportunity to show that they are an heir, because our probate code clearly states that they should be. And so the only way for us to determine in those situations or situations that have facts like these would be, as you say, to either have a trial on the facts and determine if there is if the court believes after hearing the evidence that there is an heirship, or we need to proceed to one of the other factors. And I believe that the blood test would apply here, because again, the statute states that there are 3 different people who are there, as has been said multiple times. Children means biological children, including a posthumous child, children adopted as provided by law, and children whose parentage is or has been determined under the Kansas Parentage Act or prior law. With the Kansas Parentage Act listed separately, that can't possibly include the definition of biological children. As Mr. Mills has put forth, biological children must mean the actual biological definition of children. And in order for us to determine that, excuse me, that was my, don't forget the kids alarm. Biological children must, the easiest way with the modern technology that we have is a DNA test at this point. And so while I would love to avoid the expense of a trial or an exhumation, if Mr. Mills's client, Miss Holderman, is not willing to accept that Miss Williams' client is indeed an heir, then I think that we have to put it to evidence, which means a trial.
All right. Thank you, Mr. Weta. Statements are appreciated. Ms. Williams, is there any room here for a compromise? Would a mediation by a trained professional be helpful to get Mandolin and your client together on perhaps resolution of financial issues or otherwise?
I don't know, Your Honor, because Ms. Holderman has seemed so intransigent on this issue. That someone she once called a cousin, now she wants her to take nothing. And so I don't know if Ms. Holderman, you have to go to mediation. For mediation to be successful, there has to be a spirit of compromise. And I'm not sure that I'm getting that from Mr. Mills and his client at this point. I will tell you, we have initiated DNA testing. My client's has been analyzed. We're still working on her great uncles. So eventually we will have actual DNA evidence, short of exhumation, but obviously exhumation still on the table, something that can be done. We will engage in mediation if the court feels that that's an option. I'm just not sure that Mr. Mills's client is willing to go into that with the spirit of compromise that you have to have for mediation to even be possibly successful. That's my concern.
Your Honor, I'm tired of my client getting bashed all the time. The bottom line is she's asserting what I believe is the appropriate case law and providing you the case law, which we've tried to do as best as I can find it. Okay. And so as far as whether she's willing to settle this case or not settle this case, if you recall, Your Honor, you talked about that at the last hearing. And I've heard no communication from counsel or her client that they would be willing to engage in any type of settlement negotiations. The other thing that I would point out, Your Honor, is it seems a little, and I'm a little worried about this, and I truly am. We've got these four people who supposedly have an interest in this estate. We've not heard a thing from them. We've tried to contact them. Counsel has, I have, and I don't know if we even have the right address for these people, And so it concerns me that I'm sitting over here trying to negotiate something with somebody else that might impact the amount of money that they may have. So I don't think it's really almost proper for us to leave them out of the loop. When
you make a good point, Mr. Mills. Mr. Wetta, do you have a handle on how to contact these four children of Esme Pearl?
We have addresses that we believe are good. None of the mail has been returned. They've chosen not to participate. But I would say based on the court's orders at the last hearing, where the court stated that they would receive, we're talking about an heirship. You don't have to enter your appearance in an estate to receive your what is due to you under the statutory provisions. And I share Mr. Mills's concern to an extent. If the settlement is anything other than an entire share for Miss Williams, or the share that Miss Williams' client is entitled to, if she is indeed Mr. Kinnon's daughter, if we get outside of those lines, it could absolutely affect the share of those four children. But in order to do that, I think the court can appoint a guardian ad litem to represent their interests in the mediation. But then we're just, again, adding additional expense to that mediation, which frankly is going to be the same thing that we would hear at trial. And so, again, I've got some concerns along those lines. And frankly, Mr. Mills makes a good point that they are not represented in this matter. And so for us to compromise any claims, it would have to either not affect their share that they would be entitled to under the statutory provisions as the court's ordered previously, or we would have to have someone in there to represent their interests. And I frankly cannot do that. I have to try and treat every single beneficiary exactly the same when representing my client, the personal administrator. So.
Court currently does not have a perception that mediation might be fruitful in this case. I think the parties are too entrenched. And I do share the concern that there would be a class of beneficiaries that wouldn't be adequately represented, even with a guardian ad litem, because obviously any possible settlement could impact the amount of their interest unless Ms. Holderman were to bear, for example, the 100% out of her share of any thing that's paid to Susan. Seeing that highly unlikely that would be an agreement reached, it does not appear to the court that mediation is feasible, at least not at this time. Turning next to what I think the ultimate solution might be, Ms. Williams, I will task you with this. I need you to make an investigation of what it would cost, I want to see something in writing from who would exhume this body, what the procedure would be for gathering of the DNA, because I don't know, obviously, I don't know who would do that. Probably someone from the DNA analysis lab would have to gather
Yes.
the sample,
And
maybe even from the cemetery scene, which
Yes,
just
Your Honor.
seems grisly to this court.
Yeah, I talked to one company who said that they could do that with a court order. Yes.
Well, okay, and then I'm going to task you with the responsibility of drafting a proposed court order to send to Mr. Weta and Mr. Mills. Now, Mr. Cranmer, you still stay involved in this, and you're certainly welcome at all times. Your clients have been determined essentially not to have an interest in this estate anymore. So your position here, Mr. Cranmer?
Thank you, Your Honor. I think that I've stayed quiet because of the ruling of the court. However, I will tell the court that my clients do want me to explore pursuing an appeal. And that may throw a wrench in any mediation, which you've already determined is probably not feasible anyway. And we still rely on the Strobel case. And I know the court's position on that. I'm not going to relitigate it. But I think the court and everybody needs to be aware that I do think my clients are going to certainly entertain an appeal.
All right.
So how that
include Mr. Cranmer in any communication then, Ms. Williams.
Okay.
As well, obviously, as the court. And I don't know in what form you intend to send this, but I need to know who's going to exhume this body, what's going to be involved, how much it's going to cost, and then how the DNA sample is going to be gathered, chain of custody, and how it would be tested.
Okay.
Obviously, the most effective DNA test would be on the decedent. In other words, the suggested father himself, Mr. Kennedy.
Okay.
He didn't leave a brother alive?
I don't know of any brothers that are alive that we have been able to find, Judge.
Okay.
Yeah.
Okay.
We're not positive, but as far as we know, there are none living that we know of. But you want me to basically give you a document on who can do it, how they'll do it, procedure, money, etc.
Yes.
Okay. I just want to make sure I understand. Thank you, Judge.
Yeah, and Your Honor, just for the record, and in order to potentially help Ms. Williams, I have secondhand knowledge of an exhumation that took place in a proceeding similar to this in Sedgwick County, so I can help put her in touch with the attorney who was the special administrator's attorney in that case, and help her get some of that information.
That would be helpful, Mr. Weta. Thank you.
Mr. Weta.
Your Honor, I have another procedural question, if I could ask it, Your Honor.
You may.
Since Mr. Cranmer brought up the fact that he was going to appeal, and we're going to be having this journal entry signed, is he going to have to file a motion to amend the journal entry so he can file an interlocutory appeal, because we don't have a final order? And it seems to me, if we're going through all these gyrations, and if Mr. if Mr. Cranmer is correct on an appeal, then we're spending a bunch of time and a bunch of money that we ought not to be doing if he is correct. I disagree with his assessment. I agree with the court, but if he's going to assert that, then I think now would probably be the time to do that, as opposed to, waiting till, and I don't know if you're considering this order that you entered to be a final order as it results to Mr. Cranmer, or if you don't consider it to be a final order as it meant to Mr. Cranmer. And quite frankly, Your Honor, as to your position that the four grandchildren should take, I respectfully disagree with that, and I may want to appeal. I have to talk to my client, but I may want to appeal that on an interlocutory basis. So I'm not sure where we're at from a procedural standpoint right now.
It's a fair question, Mr. Mills. It's been the court's experience that the Kansas Court of Appeals generally disfavors piecemeal litigation and piecemeal appeals. It seems to the court, and I certainly can't make this ruling at this time, but it seems to the court that the ultimate final order in the case is the one where this court ultimately makes a determination as to the disposition of this estate. In other words, who's going to receive what share. That way, everyone's interest has been determined at that point, either favorably or unfavorably, and that appeals would naturally, if any are going to be filed, would stem from that final order. Now, if counsel sees it differently, you have to protect you and your client's own interests. But certainly that's how the court would see it. And certainly this court has specifically reserved and has not made a final determination as to the various shares of the possible claimants in this case. So
Well, I would be willing to stipulate to what the court has just said. I just don't want to have either Mr. Cranmer or myself on the outside looking in, and somebody says, "Well, wait a minute, you should have filed an interlocutory appeal, and you're too late. King's X, you're out." And so, if everyone is agreeing that we can wait till your final order, then I guess if we'll all stipulate to that, then I guess I don't have any problem. I think it's the correct thing to do.
I think it would be a fallacy to think that we could stipulate to appellate jurisdiction.
Yeah.
Either they have it or they don't. And they make that determination ultimately as to what their jurisdiction is.
Yeah.
But I'm just saying that that would be my view, that until that final order is entered distributing this estate in specific shares, in other words, all of these issues have to be determined. Certainly, Ms. Davenport's issue has to be fully determined. This court's in no position to make that final order regarding disposition of the estate. And it would seem that all appeals would stem from that final order.
Okay.
But your own research would determine whether that's a proper position of the trial court or not.
Yeah.
But I understand the concern, Mr. Mill. All right. Ms. Williams, I think you know what your task is. And if you
Yes,
maybe
Judge.
confer with Mr. Wetta, it might help streamline things.
Yes.
How much time do you think it's going to take you to get that? I'm just,
Yeah.
why you be realistic with me?
3 weeks, maybe.
Okay. I think that's very optimistic, and I appreciate
It may
your
be,
diligence.
Judge.
Well, I'm going to look for a review date, counsel.
Okay, I will endeavor to get it done.
I don't want this to fall off the court's calendar. I want to review this case relatively soon with this information available, so that
Okay.
the court can make an appropriate determination whether that will be an order of this court. A
Okay.
proposed order would be very helpful to
Proposed order.
this has been done before, I'm sure.
Oh, yeah.
Other cases, I would be interested in what wording of the order is appropriate for this type of unusual proceeding.
Okay.
Okay. We're looking very late November.
And then we get into Thanksgiving, Judge, so we may need to look at the beginning of December.
Friday, December 1 at 10 o'clock in the morning.
Your Honor, I have a standing obligation. Would the afternoon work for the court? I could make the afternoon work better than I could the morning.
Well, my assistant marked off that afternoon,
Oh, sorry.
so I'm sure she had good reason for doing so. Because she now tells me that I did that. So I stand corrected. If I were to set this at 1:15 in the afternoon? Oh, yes, 1:15.
Your Honor, that worked for me. This is Russell.
Joy?
That would be tight for me.
Well, I can move it back a little bit.
Oh, please, if we could go a little later in the afternoon, I would appreciate it. Thank you.
We were to set it at 3 o'clock.
Yes, that would be much better for me, Judge. Thank
All
you.
right. Halderman case will be set for review hearing by Zoom, 3 o'clock Friday, December 1. And hopefully, Ms. Williams can have all of that information, which the court had asked her to provide.
Yes, Judge.
Mediation will not be ordered at this time. And the court denies Mr. Mills' request to deny Ms. Davenport the opportunity to further pursue her claim that she is a legal heir of this estate.
Thank you, Judge.
All right. Very well. Mr. Wetta, anything further at this time?
Nothing further, Your Honor. Thank you.
Ms. Williams?
Nothing further at this time, Judge.
Mr. Cranmer?
Nothing further, Your Honor.
Lastly, Mr. Mills.
No, Your Honor, nothing further.
Very well. Thank you all. If there's nothing further, then the Halderman matter will currently be in recess, and this meeting may be ended for all.
Thank you, Judge.
Thank you, Your Honor. Would you get her?
This is in the District Court of Butler County, Kansas, case entitled "In the Matter of the Estate of Larry Halderman." It's case number 2022 PR 168. Starting with the estate's attorney, would counsel announce their appearances for the record, please?
Good afternoon, Your Honor. May it please the court, Trent Wetta of Hinkle Law Firm appears on behalf of Judy Sullivan, the administrator, CTA.
Joy K. Williams on behalf of claimant Susan Davenport, who also appears with me at my office via Zoom.
Your Honor, Russell Mills appears on behalf of the beneficiary, Mandolin Halderman, who also appears in my office.
Very well. I'll also note that Mr. Cranmer, who has appeared at a number of hearings in this case, apparently was unavailable after the court had established this court date at our previous court proceeding back on October the 30th. I'll just note that he has a representative of his office here, ostensibly in the view of the court, to schedule a hearing on his motion for relief from judgment.
Correct, Your Honor.
All right. Court will take that under advisement, and I'll make a ruling as to whether I'm going to set a hearing on that as part of today's proceedings. But before I do that, I want to address several other matters which are before the court. I note that pursuant to this court's directions, and I think I'm going to go ahead and just read the pertinent parts of my docket notes from the last hearing, since I don't believe that there was a journal entry that anyone prepared to document that. Is that correct, counsel?
That's correct.
My understanding, Joy was to prepare that.
I didn't.
My notes say this: the court grants no relief to Mills to preclude Susan from pursuing her claim as an heir, mediation considered, but given parties' unwillingness to consider compromise, the court declined to order mediation. Ms. Williams was to provide the court and counsel a summary of procedure and cost of exhuming body of Susan's alleged father, Larry Kennan, for purposes of DNA testing, noting that it was his body was in a Eureka cemetery. Review hearing set for today. So it doesn't appear that the court assigned a responsibility to prepare a journal entry to any party. And I'll just note that other than the court declining to consider mediation, I don't know if there was anything substantive really to journalize there. I do note that in pursuant to the court's direction, Ms. Williams has, and I'll give her credit for this, done exactly what I asked her to do. She has presented to this court a report to the court regarding procedure for exhumation of the body and a cost estimate to all the different sources necessary to accomplish this. Did have one question for you though, Ms. Williams.
Yes, Judge.
The cost to the city of Eureka,
Yes.
I'm not sure exactly what their role is. If private companies are going to be doing essentially the excavation and opening of the vault and all of such things, what is the city of Eureka's $1,100 fee for?
Your Honor, I agree with you. I kind of questioned that myself, but when talking with the funeral director at the Zimmerman Funeral Home, he made me aware that there are fees that the city of Eureka will charge. $550 to disinter and $550 to reinter. And I think it's pursuant to an ordinance. In fact, I went in and looked, and the city of Eureka has ordinances pertaining to the Greenwood Cemetery, and they have fees involved and regulations involving the interment and disinterment of a grave. So I got that amount from the funeral director, who said that we will have to pay that amount to the city of Eureka.
For essentially disturbing their cemetery ground.
Basically, yes, Judge. And I'd be glad to call the city of Eureka and explore that more, but that was my understanding after talking to the funeral director. Yes.
I was just interested in the origin of those costs in light of your explanation as to who'd be doing the other work connected with this.
Yeah, and I agree with you, Judge. I kind of raised my eyebrows at that also, but I wanted to include it because I understood that it could be a potential cost.
Certainly, and I appreciate that. Mr. Mills, in response to the report, has filed petitioner Mandolin Holderman's objection to order for exhumation of body and comparative DNA testing. I trust all of the attorneys in the case are aware of Mr. Mills' objection. Ms. Williams?
Yes, Your Honor, I just got it this afternoon, so I've only had about an hour and a half to review it, but yes, Judge, I have seen it.
All right.
Your Honor, Your Honor, I would like to say that I just received the paperwork that counsel provided to you, her report and her proposed order. I've received that this morning. I had to scramble to get this together, this report, this objection, which I believe is founded in the law and in the facts. And I believe the court should not allow an exhumation of the body and this testing of the body. And I would note from my review of this report that she has done, it doesn't set out any statutory authority. It doesn't set out any case law that it advises the court of how it can issue the orders and for what it can issue these orders for. And I believe that we have to start there to understand just exactly what you can do and how you're authorized to enter an order like this. And so until we've had time to review that and determine that you do have the ability to issue those orders should not be authorized. And if you go through, and I will tell you, Your Honor, I didn't feel like I had sufficient time to respond to this report, but I did the best that I could. I will tell you, for the short amount of time that I had. And so, but Your Honor, what I would say is, if you went through my objection, I think it pretty well sets out that what we really need to do, Judge, is we have to determine whether she has standing in this case at this point in time, whether she can really pursue this case. And when you look at my motion for reconsideration, if we look at that today, you'll see, I think, extremely clear instructions by the statutes and by the case law, some of it, Your Honor, that you frankly were involved in the MF case, that will show the court that she's too late. Her claim is barred. and to order a uh, uh, DNA testing and digging the body up, this exhumation, is not authorized by law and is set out clearly in my motion for reconsideration and in my objection.
Well, Mr. Mills, explain here,
I cannot
please
hear.
summarize, if you will, why you believe that she doesn't have standing.
Okay, she doesn't have standing because essentially the statute of limitations has run, Your Honor. If you look at, and I know I'm jumping around here a little bit, Your Honor, but the In re Estate of Foley case that I reference in my petition for reconsideration, all right, it talks about genetic testing. And it talks about how we came to have genetic testing in the statute as a presumption of paternity. And it goes through the statute and tells us that, excuse me, that we got to consider the statute as written. We got to consider all the, not only the statute regarding genetic testing or authorizing it if there was a DNA test done before the death, but we have to look and see if that did not occur, which it didn't. What does the statute say? And the current statute is 232209, which says if you don't have that presumption of paternity, okay, whether it's DNA testing being done before the death or whether it's open notorious recognition of the parentage by the parent, the alleged parent here, then we have essentially a 3-year statute of limitations from reaching the age of majority. She is obviously more than 3 years past the age of majority, meaning Ms. Davenport. So the statute of limitations has ran to pursue.
When did her cause of action accrue?
I'm sorry?
When did her cause of action accrue?
Her cause of action it accrued really on date of birth if she had somebody to come in and assert the claim.
Well, that argument, Mr. Mills, that argument ignores the fact that she essentially was adopted out. She had no right to seek child support from Larry Kennan.
We're not asking.
Her cause of action, would it not have accrued when Larry Kennan, well, excuse me, when the decedent in this case passed away? At that point, her rights as an heir accrued for the first time. While he was alive and while this decedent was alive, she wouldn't have had any claim, would she?
But her claims depended, Your Honor, depended upon her ability to prove that she is the daughter, that the paternity would be established. And you have to look at the Foley case. The Foley case was an estate.
What page did you cite that, counsel, of
Your Honor, that's in my motion for reconsideration.
Well, I was just asking what page is it on?
And if you look at that, the last portion of that sentence of that opinion basically said that genetic test results must be known before a presumption of paternity arises. If no genetic test results to establish paternity have been accomplished before the Parentage Act is commenced, and this is the prior statute, 38111582, which is now 232209, is applicable. And that's the statute that says you got the 3-year statute from the date of becoming an adult, okay, of minority. So it's black and white, Your Honor. But on top of that, you know, the In re MF case that you were involved in, Your Honor, talked about how the court recognized a timing element was significant to determine these presumptions of paternity, and specifically the one about being open and notorious. Okay. And it said, under several, and I'm quoting word for word, your case, the MF case. Under several of the presumptions, our legislature has made the timing of the child's birth significant. KSA 219 sub 232208 A1, A2, and A3. The court determined that each of those deemed the timing at birth significant. Okay. And they went on and said, these provisions support the idea that it is the moment of birth when Kansas law deems the child to have either one or two parents. And so, Your Honor, I don't know if you remember this, but I was not aware of that case until just the day of the hearing, or the day before the hearing that we last had. And I advised the court of that. And that's when you had advised me, well, I was the judge, involved in that case at the district court level. And so I thought, well, okay, I better look into this. And so I did. And what I found, Your Honor, was the more recent case, which was in the matter of the estate of EA. And what that case said, that dealt with a grandparent who was trying to have himself declared to be openly and notoriously say he was the father of this child, which was a legal fiction. It just wasn't the truth, but he wanted to make that claim. And what the court in the EA opinion said was, and this is a 2022 opinion, I got the opinion number, Your Honor, and it's in my motion. But it said anyone trying to establish a presumption of paternity by openly and notoriously claiming for parentage must do so at the time of the child's birth. Can't happen. That's it. End of story. And so what I would say, Your Honor, is where is the case law? Where is the statute authority that overrides the court in either the MF case or the Foley case or parentage of EA or 232208 or 532209? I can't find it. It's not there. And I would love for one of the other counsel to explain to me how these statutes and this case law that we're supposed to be following should be disregarded. I just don't believe that it can be, Your Honor. And I think if that's the case, we don't have to go to whether this body is exhumed or not, because we are doing a useless act because she's out of time and therefore has no standing to pursue this claim. It's over. So, Your Honor, I could probably go on, but that's the kind of the gist of where I'm headed with this. The other thing too, Your Honor, is, I was concerned because I think you were concerned about the Record v. Ellis opinion that talked about open and notorious in general recognition by the father. And it was an old case, 1917 case, and you thought, as a matter of fact, you brought up the question, well, is that, kind of still the law, or is that, surely there's some other case? And that's when I said, well, the MF case, and I told you about that. And so that kind of led us into that. So I decided to go look at the record opinion, and I shepherdized the record opinion all the way through to not today, but maybe 2 weeks ago. And I also shepherdized the statute 59501. And as crazy as this may sound, Your Honor, the record opinion is still, to this day, the opinion that gives a clear definition of general and notorious. And I set that language out in my motion for reconsideration. She can't meet that burden even under the old case law, Your Honor. And so until she can meet that presumption, you've got to have that presumption first. you can't go to do anything else, and you're too late to do the request for the DNA testing under the statute. And so if there's some other case law out there, Your Honor, that I haven't found, then I apologize to the court. But I'm trying to do my best to get this information to you, to get the case law, to get the statutes to you, which I believe are just absolutely clear. And I've not heard anyone be able to argue and say, oh no, this statute doesn't mean this, or that statute doesn't mean that. And they don't have any case law to back it up because it doesn't exist. That's just as I see it, Your Honor. And if I'm wrong, then somebody needs to present their argument to you to explain why we can disregard the law. Because I think that's what this almost boils down to.
Well, Mr. Mills, I would just make the observation, being somewhat familiar with that MF case, that was a case involving the rights to a child born during the existence of a same-sex relationship.
Yes, I understand.
I don't think that opinion was written with this set of facts in mind, which are substantially different. I think we'd all agree. So I question whether MF would be a basis for binding precedent that this court should apply in this particular case. Furthermore, if you're taking the position that the relationship had to be established at the time Susan was born, she's the baby here. How was the baby supposed to assert her rights back then?
Anyone, the statute allowed anyone on behalf of the child to assert that claim on her behalf up to the age of 18. And then after she turned 18, the statute allowed 3 additional years for her to assert the claim. One of the problems, Your Honor, I think that the court was recognizing was the very thing that we're facing. We're facing a situation where this lady was born all these years ago. We have, and you, Your Honor, allowed the claimant to get her adoption records. We still don't have the adoption records, Judge. I think they need to be ordered into court so the court can review them. But what we've been told in those adoption records is that the putative father, Mr. Kennan, did not, his name's not on the birth certificate. It wasn't, he didn't sign any acknowledgement of paternity. And on top of that, he wasn't asked to sign off on a consent to an adoption. And why was that? Because the birth mother in the adoption case said she didn't know who the father was. So we don't have either one of these parents openly and notoriously or in any way acknowledging at the time of the birth, or really even later, that is on the record in any way, that he was the birth father. So the adoption records themselves, I thought, Your Honor, would clean this up. But evidently, they're wanting to pursue it. So we had another hearing, Your Honor. And at that hearing, we were told, well, we've got some DNA samples from a great uncle or something like that, and we're going to go get this tested. And what's happened to that? We've got no information about that either. But yet now we're going to go through $12,000 of expenses, and she's asking the estate to pay for something that she has the burden of proof on. I don't think that the court ought to entertain causing the estate to have to pay to meet a burden of proof that I don't even think she has the right to even try and attempt to meet. So, Your Honor, I hope that you can take the time to review my motion and my objection. I've tried to, as briefly as I could, go through it. Now, I will tell you, Your Honor, and I want to make sure that the court understands this, and this is no, I greatly respect you, and I appreciate all your service. But I do believe that if the court is not inclined to follow my argument, then I believe that this is an issue of importance to the people of the state of Kansas. That does need to be determined, and it's obviously extremely important to the litigants here that we know exactly what the law is, and that we don't go spending $12,000 or whatever before we do know what the law is. And so I would, if the court is inclined to rule against me, I would ask the court to allow the language of any journal entry to contain the necessary language under 60-2102 to assert an interlocutory appeal to get these issues, resolved before any order might be executed on as far as digging up this body. I will tell you that.
All right, just a moment before you go forward. What issue would be appealed?
Well, the issue of whether or not she has the ability at this point in time to even assert this claim, like I just got through saying, or does she have to meet the presumption before she can come and ask you to even do this testing? I think that's the very first thing you have to do. And if she doesn't meet that burden, then she almost doesn't even have to go to the DNA testing if she does. But I don't think she can. And so the point of the matter is we have a statute that says what it says, and it says, no, you got 3 years. You're saying, potentially you could be saying, no, that doesn't apply. I say that it does. I think that has to be clarified given this set of facts. And I think what's even more interesting in this case, Judge, is that you're in a position where you have to interpret, I think for the first time, 59-615 as it applies to a set of facts like this. And there is no case law out there. It doesn't exist that I can find. And I don't think any other counsel can really find any issue, any prior case law to that effect, that this interpretation. The other thing, Your Honor, and I know I'm maybe rambling here, but I have another motion for reconsideration that affects the grandchildren, and your determination that you could find, the disinherited children to be predeceased. I couldn't find any case law to support that either, or any statutory authority. And I have that set out in my motion, or my petition for reconsideration on that. I think that's also a question that needs to be determined by the higher court, if need be. So obviously, it all starts and begins and ends with your decision. And then if you believe that I'm wrong, which obviously you have that power, then so be it. I just have to appeal those issues. And the question is, are they going to be on an interlocutory basis, or are you going to determine these to be final orders? And the one comment that I would like to make too is, I know Doug Cranmer. I respect Doug Cranmer. I believe that he ought to have the right to present his voice and have it be heard on all of these issues. I don't know if the court has entered orders that says he has no standing. I think he does, and I know he has filed a petition for reconsideration as well. I think all counsel should be allowed to participate in that as well. So in fairness to Mr. Cranmer, it seems to me that we should not enter any order, at least until he has the ability to participate, because whatever rulings you may make on Ms. Davenport's position could ultimately directly affect whether it's the grandchildren or whether it's Mr. Cranmer's client.
Hey, Russell, I don't think the judge is in the room anymore. Mandy,
Oh.
can you look at that? It looks like, yeah.
Oh, I think you're right, Trent. I'm just rambling on.
Can you guys hear me?
Yeah, you're pretty quiet, but we can hear you now.
Yeah, my speaker's messed up. I apologize.
Is Doug here now?
Yeah, I just got here from my other hearing, so
Oh, okay. All right.
I just sat down like a minute ago.
Oh,
So
all
I
right.
haven't heard anything.
Well, I was arguing on your behalf, Doug, so that you could be here.
Well, I heard my name, my ears were burning, but I don't know what's happened up to this point. I have my legal assistant in here with my calendar in case things need to get scheduled, but I can take over now, I think.
Okay. Well, we lost the judge, so we don't know what's going on.
Yeah, I see
Give him
that.
a few minutes. Give him a minute to get on here and we'll get him back on here.
Is this mine?
Hey, Doug. Just to give you a quick rundown on kind of where we've been in the last half an hour. Judge determined that we didn't have a journal entry from the last hearing. He did find that Joy submitted exactly what he had requested. With regard to the kind of procedure and cost estimate of what that exhumation might look like. He did have a question for her about some costs to the city of Eureka that got straightened out, and apparently they've got a kind of an exhumation and reinterment fee that comes along with that because they own the piece. And then basically Mr. Mills has been arguing since then regarding his motion on that he's presented in front of the court from there.
Okay.
Okay, I see I have Mr. Cranmer on the meeting now.
Yeah, sorry I'm late, Your Honor. I got my other hearing got finalized, so I signed on if that's okay.
Well, your assistant was very patient, which I appreciate. I regret the internet service interruption, which disrupted proceedings here just a few minutes ago. Mr. Mills was apparently in the middle of his presentation at the time. Mr. Mills?
Yeah, Your Honor. So I had gone through my motion for reconsideration, but so I don't want to, go over that again. Other than I would tell Mr. Cranmer that I did present arguments that I believe are set out within the motion, and I believe are controlling in this case, and that I did object to the exhumation because there is no case law or statutory authority for that. In fact, Your Honor, as to that, in the very short period of time that I've had to try and address this, I did look up what the Kansas statutes say about exhumation of bodies, and Your Honor, that statute is KSA 19724, and it's the only statute I could find quickly regarding exhumation of bodies. And it says that statute allows the court to have power to exhume a body for the purpose of ascertaining the cause of death. Obviously, that's not the issue that we have here. So
Well,
I would ask,
Mr. Mills, the existence of that statute, which enables a county attorney or a district attorney to apply to a court to exhume a body, deals with their ability to perhaps test a body, do an autopsy for purposes of criminal prosecution or investigation. Since it would appear that the legislature has given specific authority for that, it doesn't necessarily preclude exhumation of bodies for other purposes, does it?
well, Your Honor, I think we can't be reading into some statute that no one's even referenced that there's a right to do that. we're not a legislature. We can't, say, well, I think that the legislature would want us to be able to do this and have general authority by the district court to enter an order that is, this is very impactful to my client, Your Honor. You're talking about digging up her relative and dismembering him for some speculative reason from some lady who claims that she might be a relative and might be entitled to make some claim here. That's a pretty drastic thing, at least in my client's view. She does not want that to happen. And there should be some statutory or case law authority to support such a severe thing being done to my client's relative. We don't know
All right,
which
well, okay, let me
Susan
stop you there,
Davenport's
Mr.
relative.
Mills. Let me stop you. Wouldn't you think that the decision whether to exhume a body most logically, if we're talking about family or relative considerations, be made by the next of kin?
Your Honor, I'm sorry. I could not hear what you said.
I'm just saying that if there has to be a decision made about whether a body should be exhumed or not, don't you think that the relative in the best position to make that request would be the next of kin?
Yeah, and she's not one. My client is.
Objection, Your Honor.
No, wait a minute. I understand, Mr. Weta. Let me finish my discussion here with Mr. Mills. Mr. Mills?
Yes.
Okay.
What I'm saying, Your Honor, is what we have.
Indeed Larry's daughter. If Susan is indeed Larry's daughter, she would be next of kin, wouldn't she?
Susan is not Larry's daughter. Susan is alleging that she is John Kennan's daughter.
I apologize. I used the wrong first name. Not Larry, but Johnny.
Okay.
She's
alleging she's the next of kin. She has no evidence to support that at this point in time. In fact, we have evidence that is contradictory as submitted to the district court in Sumner County, Kansas. So all we have is some proffers that I think were not timely submitted and should not be reviewed by the court, that are self-serving, that are not supported by any other evidence out there other than the claimant and her immediate family making some allegations that, again, I think are outside of the new timeline required under EA. And even if it's not under the new timeline required by EA, it doesn't even meet the requirements of the record opinion. So she is not a person, I believe, who has standing as a relative. Your Honor, I could file the same affidavits and say, hey, wait a minute, he was my father, and I could have my wife and my son and a daughter-in-law, write out a son-in-law write out a statement saying, well, I heard him say something. Well, you know what? We're never going to get to hear anything from Mr. Kennan, and yet we're going to spend. She's now requesting us to spend $12,000 to meet a burden that she should have. This is not the estate's burden of proof. It ought not to be required to pay to try and establish some claim of someone who has to be, at this point, Your Honor, I would say presumed to be not a relative. When we look at the information that the court has already allowed her to get, the adoption records. And I want to know, Your Honor, too, what happened to this supposed claim of being able to get DNA evidence out of the uncle. We've heard nothing. But yet now we're being asked to go ahead and have you authorize the payment of $12,000 from the estate. If I was representing the estate, I'd be pretty fired up about that. And I wouldn't want that money going out the window. But that's up to Mr. Weta. But the bottom line, Your Honor, is if we're strictly looking at who is the known family, that would be my client. That would be the disinherited children of the testator. They would be, people who might have standing. Once you get past that, maybe the grandkids, at least my position on that, Your Honor, is they don't have standing either. But if their parents were in fact dead, then yes, they would. But we're not talking about a relative coming to the court and saying, a known relative coming to the court and saying, Judge, we need to exhume this body and we need to essentially dismember it. If you think about that, Your Honor, if somebody wanted to dig up my father and dismember him,
What do you
they'd
mean?
have one
dismember
heck of a fight on their hands. And this is
Okay. Apparently, you're
this
not
is just
going to answer
not
my
supported.
question.
He asked you a question.
I'm sorry.
What do you mean by dismembering?
If you look at the report, Your Honor, that she submitted, that the claimant submitted, it says that the body is going to have to be potentially cut up. And it says decedent's body to retrieve and take from decedent's body such materials as deemed appropriate for DNA extraction, including but not limited to decedent's femur bones, knee bones, patella, and or metatarsal bones. I think you got to cut the body up to get those bones to deliver them for testing. That is dismembering the body. That is revolting to my client that any court would consider doing that on a maybe I might be a relative, but I don't have any proof of it. But that's where we're at. That's what she's asking for. So,
All right. Mr. Williams,
where she's at.
Ms. Williams, I'm going to go ahead and give you the floor for a moment because I have a couple of questions for you.
Certainly, Judge.
Is your client seeking exhumation of this body for the purposes of DNA testing?
Your Honor, yes, we are. Because we're working on DNA testing, but we do not have it yet. We submitted the great uncle's DNA, but the lab said they didn't receive it. So we'd have to retake his DNA and start that process again. They have received my client's. We know that she has matched up with some other kin and relatives. So we are working on that. And yes, we have some DNA evidence. Yes. But given the litigiousness of this, we are very open to exhumation. This is, I have to say on behalf of my client, a bit offensive. My client is more than maybe I might be a relative. It is members of Mandolin Holderman's family, to borrow Mr. Mills's wording, that have claimed Susan to be a member of their family and the daughter of Johnny Kennan. I'll just remind you that she was included as the daughter in the obituary by the grandmother. She was included on the headstone as the daughter by the grandmother, Ladima. This is more than just a maybe I'm the daughter. Mr. Kennan held my client out notoriously as his daughter. I know they're trying to shape the argument and the hurdles to benefit them, Judge, but to notoriously and generally hold someone out as being your child, I don't think you have to take out a full-page newspaper ad. You don't have to start every conversation you have with someone with, hey, guess who my child is? Where it's appropriate, you identify yourself as the child's father, or you identify that person as your child, and that is what happened here. It is not Mr. Kennan's fault or my client's fault that due to the politics between the family, the time that she was being born, 1967, that Mr. Kennan was cut out of the process of determining who was going to raise Miss Davenport. My client was able to reconnect with Mr. Kennan as an adult. And for several years there until his death, they had a relationship. She told me, one of the first things she told me was, I called him up and I said, do you know who this is? And he says, yes, you're my daughter. Mr. Mills is trying to make it sound like you have to have everyone in the world knowing that he claimed her as his daughter. That's not what general and notorious means. To all the people who came into his past, where the question about his relationship to Susan came up, he claimed her as his daughter. And most significantly, he never said she wasn't his daughter, to the point that, once again, as Mr. Mills said, not my client's relatives, but Mandelin's relatives accepted her as their granddaughter, their cousin, and included her in Mr. Kennan's life in that way. The last 2 weeks of this man's life, knowing that he was dying, he spent half of that time with my client. You don't spend that with someone who maybe might be your child. Your Honor, just to use just to go over some of the arguments. We know.
Just a moment before you do that, because
Certainly, sir.
Mr. Mills has raised a procedural defense in your case.
Correct.
I think one of his suggestions is that you never properly petitioned for exhumation of this body.
Yeah.
He seems to suggest that there might be some procedural requirement that there be a formal petition for this relief, which you've never filed.
Correct, Your Honor. And basically at the last hearing, Your Honor said that you were.
And then you say, well, you're open to it. That's not the same thing as petitioning.
I apologize, sir. I'm sorry, there was
No, go ahead.
disconnect. I may have thought you had stopped when you hadn't, sir. At the last hearing, Your Honor said that you were looking seriously at the aspect of ordering exhumation and asked me to put together that report with an order, a proposed order, and I did that. If we need a petition, I can have it on file by Monday. That will not be an issue. I do think the court can sua sponte order that. I think Mr. Mills is incorrect that just because that there is a statute allowing a district attorney or county attorney to pursue exhumation when they're looking at possible criminal charges doesn't mean that a court of equity can't order exhumation. In fact, I can tell you in the very brief time I had to research this, I found that the city of Eureka had a procedure and fees basically for exhumation and reinterment. I saw that the city of El Dorado had that. I believe it was El Dorado that even went so far as to say that they needed an order from a district court. I saw the city of city of Hayes also had ordinances regarding this. So I don't think that this is prohibited, and I don't think Mr. Mills can show that it's prohibited. I think a court of equity can, where it finds that it is necessary and it's the best source of proof, that they can go forward and order an exhumation. And I think I put that into my order, that it was the best source of information, determinative information for the court. Did I answer your question?
Right.
Sorry. Yeah.
Yes, you did.
Okay.
The second question I would ask you, I think Mr. Mills makes a good point regarding this being initially charged to the estate. The court can certainly apportion costs and expenses and attorney fees ultimately in this case, which this court is ultimately going to have to do regardless of the outcome. But what about the initial cost being borne by the estate? Because should your client prove to be an heir, I don't think that that's a big deal. If it's shown that she is not an heir in this case, then the estate has incurred a substantial expense. How does your client intend to guarantee that or pay that back should she be wrong about her assertion of parentage? Can she put up the money, even if it's held by the court initially, as a security for the expense?
I'd have to discuss with her putting up a surety, but if it's what's required, we will make it happen, Judge.
I'm talking about her posting the money.
Posting the money. I would have to talk to her in more detail about posting, I assume about $8,000. I do think it's an expense of the estate to determine the heirs. I believe that we have shown you, we have tried to circumvent this by showing you proffers that Mr. Kennan held her out notoriously as his child. I think that that should be very good proof that this isn't a maybe wannabe situation. This is a situation where there really is no question of the people that are involved, that she is the child of Mr. Kennan. And I believe we meet the test of generally and notoriously holding her out as his child. I disagree strongly with Mr. Mills that we don't have that evidence. I think we do. And if we had an evidentiary hearing, an in-person evidentiary hearing, we would bring in a lot of testimony to show the court that he held her out generally and notoriously as his child. As so, I believe that she meets a presumption. That means that she is not time barred in pursuing an action and DNA evidence that she is indeed Mr. Kennan's child. I also think that the court has a good point in that she had no notice that she needed to make a claim until she was notified that she might be a beneficiary of Mr. Holderman's estate. And so if so, then she's under the 3-year time limit. So I think no matter how we look at this, Ms. Davenport should be given the opportunity to prove her claim, either by having an in-person evidentiary where we show that he notoriously held her out, showing DNA evidence, or exhuming the body and putting an end to this.
So you'll need to talk to your client as to whether she can post a bond of at least $8,650.
I will do so, Judge, yes.
All right. Mr. Weta, as the attorney for the estate, are you taking a position on this issue that was just raised with Ms. Williams?
Yeah, I frankly, I agree with Ms. Williams in that I believe that my client, who is present with me, by the way, Your Honor, is required to determine the heirs of this estate. And if DNA evidence is the only way to do that, then I think that we can ask for it. To bring this back around, there's been a lot of argument about the Parentage Act portion. As we discussed at the last hearing, 59501 gives 3 different ways that the court can determine who are children who can inherit. Biological children, adopted children, or those children who have been or are determined to be children such under the Kansas Parentage Act. The matter of estate of Fechner, 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 it's 432 P 3rd 93, deals with this issue directly. On page 95, going into page 96, the court specifically states, from the definition, we know that a biological child would qualify, but there are 3 ways to qualify as a child. 1, biology; 2, adoption; and 3, having parentage determined under the Kansas Parentage Act. The court further goes on to say that the statute connects those 3 by and, showing that all 3 ways qualify under the probate code. So far, all of the argument today has been regarding that 3rd piece, but I don't think that the court can disregard the fact that biology is the first way that the court can determine this. And the way for us to determine biology is not by presumption. It is simply by a blood test. The matter of estate of Fechner goes on to state that the district court does have the authority to order DNA testing in a probate matter. It's clear. In that case, there was not a deceased individual who was being tested, but instead the order was against a person who was alive. But it is the analysis in that case looks to the discovery provisions in Chapter 60 via Supreme Court Rule 144 which allows the probate code to look into Chapter 60 for that and only that reason. With regard to the other Chapter 60 arguments that have been made, without them being tied back directly into the probate code, this case is also clear that, quote, no provision in the Kansas probate code specifically incorporates the Kansas rules of civil procedure, citing in re estate of Wolf, 32 Canap 2nd, 1247. I think that the court doesn't need to go into the parentage code, but can stay well within Chapter 59 and still make these same orders, given the case law of the state of Kansas. Mr. Mills said that he shepherdized all of Chapter 50 or 59-501. If he did, he would come across this case, and this case is clearly on point for the issues that are in front of the court. And so I do think that that the court has the authority to do so. I think that the estate has the obligation to present the best evidence to the court, or if unable to present that evidence, ask the court for a petition to instructions. Frankly, if Miss Williams was not here representing her, that would have been my recommendation to my client, was to file a petition for instructions to the court to determine if we should be doing an exhumation or something else with regard to this specific aspect. I do not want to have to spend this money, frankly, but again, the idea that we shouldn't allow for the discovery statutes that do apply in Chapter 59 to be carried out seems improper to me. Furthermore, the cost here, even at $12,000, is frankly far less than what the interlocutory appeal will cost the estate in the long run. And to that matter, we filed a petition for interim fees because our calendar year is closing here shortly, and frankly, mostly as an illustration to the parties in the court on the amount of fees that have been incurred by my office, trying to keep straight all of the different petitions, all of the statutory citations that have been put here. There is some complicated, interesting implications of the probate code in the state of Kansas here, and I do think that there are some questions that haven't been asked previously, but I also think that the court can resolve all of those before we find ourselves in need of appellate jurisdiction, although that frankly is not my forte, Your Honor. So I would say that I would leave it to the court to determine. Again, we would have petitioned for instructions from the court anyway to determine this issue, because I think it's absolutely a necessary issue to determine before we can apply for final settlement of this estate. Without being able to offer the court the best information about who the heirs are and who is entitled to what share under this estate, a petition for final settlement and distribution would be premature. And so, frankly, I think we need to learn this. And so, again, I leave it to the court's discretion as to whether they will order this or not. I would say, though, that my position is on costs that, at least from this perspective, as long as the court is comfortable that Ms. Williams and her client have presented adequate evidence to move forward on an exhumation and her claim, in effect, there's good cause shown, I believe is what this probate code refers to, that if the court finds that good cause, then the court can order this, and it would rightfully be an expense of administration, as much as I would love to not spend a bunch of extra money determining who the heirs are. Thank you.
All right, thank you, Mr. Wetta. Mr. Cranber, you've joined the meeting late, but I know that you have a motion before the court. Is there anything that you wish to address the court about today?
Just briefly, Your Honor, and as you noted, I have a petition to alter or amend the ruling that you made earlier. Thereafter that, we would maintain a right to appeal if my clients, and I think my clients are going to want me to do that. If it turns out that our position is correct and that Strobel and Hainberg control this case and that my clients would take via intestate succession, then none of this DNA testing would be necessary or required, and there would be an expense that the estate would not have to bear, because my clients would take via intestate succession as the children of the decedent in this case. So at this point, our position would be the court should not authorize at least the estate paying for the exhumation or any genetic testing of Miss Davenport or Mr. Kennan if he's exhumed or whatever, at least until there's a final resolution on whether or not my clients take via intestacy pursuant to Strobel and Hainberg.
All right. To make sure I understand what your re-argument is here, Mr. Cranmer, it's my understanding that let's just review what the facts are briefly. In this case, the decedent in this case, Larry Holderman. You still with me, Mr. Cranmer?
Yes, I'm here.
Okay. I'm not sure what all that noise is about.
Okay. All right. Well, I'm gonna have to go off.
I don't know if you can hear me.
You're muted.
Yes, you're on the meeting, Mr. Mills.
Your Honor, can you hear me?
Yes.
Yeah, we can hear you.
All right. Well, I've been off for about 15 or 20 minutes here, I think. No. Maybe 10. I don't know how long it is, but I have not been able to hear you. I was totally off. I don't know. The last thing I heard was that Mr. Weta had started to speak, and then we lost him. And then we just got back on, and I heard Mr. Cranmer start to say some things, and then we lost again. We heard this beeping go, so I had to shut my phone off. So I was trying to get on the phone so I could at least hear what was going on. So I've missed out on a big chunk of the argument. That's all I'm trying to tell the court.
All right. Well, the court has issued no rulings based on anything that's been said, Mr. Mills. I will assure you of that. Mr. Weta did set forth his position on several issues, and I regret that you did not hear them. I was addressing Mr. Cranmer about his motion to alter or amend judgment, and I just wanted to clarify what his position was. Mr. Cranmer?
Yes, sir.
All right. Now, I think you take, again, I wanted to review the facts of what happened here in a very simple way. Decedent in this case left his estate under his will to his parents, specifically disinheriting by language in the will his two children and your clients, essentially. Since his parents I think you take the position in the intended gift lapsed, correct?
Well, our position is the will failed because the gift was not completed because there was no residuary clause. So therefore the will fails, and my clients would take via intestate succession, a la the Strobel case and the Hainberg case. And
well, I think you're just using crafty language to try to get around what really happened here. I think you're arguing that the gift lapsed. Therefore, the anti-lapse statute would apply in a situation of a gift lapsing, wouldn't it?
No, under the Strobel case, which is under, we say, very similar facts to this case, the intended testator or the decedent or the legatee beneficiary of the estate predeceased the decedent, and there was no residuary clause in that will, and the Strobel court held the will failed, and that the disinherited person who was the spouse of the decedent took via intestate succession. That's what we're saying happens here. The anti-lapse statute doesn't apply because the will failed. And that's what the Strobel case stands for, and the Hainberg. And the Strobel case also says specifically that being disinherited in a will does not prevent somebody from inheriting via intestate succession. That's our position.
All right. And I think that this is really a position that you've taken all along in this case. Would you agree, Mr. Cranmer?
That's correct.
All right. And you're asking the court to reconsider the case law that you've cited and to reach a different result.
Yes, Your Honor, and there's case law out there that says if I don't object and give the court the opportunity to correct what we believe was an erroneous ruling, then we lose our right to appeal.
I see. All right.
I mean, so it kind of puts me in an odd position when we're talking about too much about whether we should exhume a body or not, because frankly, if I'm right, then it doesn't matter to me, other than we don't want the estate paying for the cost of that until my client's rights have been finally determined on appeal. And if I'm wrong, then I don't know that my clients have any standing to advocate for a position one way or the other. It's kind of an odd situation. I do believe there's case law which indicates that your order with regard to my parties, my clients, is a final order that is appealable, which is contrary to what would be in a family law case. But I do have that, and I didn't bring my file. I just came straight in from my other hearing, so I didn't bring my file. But I think there's a case that at least makes me cautious enough and concerned enough that I think I need to proceed as if it's a final order.
All right. I understand, counsel. Well, there are many issues that we talked about today along filings, and I think we would all recognize we're relative to give them proper and full consideration. I'm going to take the issues which are currently before the court under advisement. I may be issuing a written ruling. I think I'll have to start, obviously, with a ruling on Mr. Cranmer's motion, because I think his point is well taken. If his clients are indeed found by this court to be the ultimate beneficiaries, I don't think there's any need to discuss any further the issues regarding Susan Davenport, paternity, exhumation of bodies, or many of the other issues that we've discussed here today. So the court will issue a ruling here in due course. Counsel, I don't want to lose track of the case, though, and I do want to schedule. I just call it a status conference at this point, for something set on everyone's calendar to rediscuss this case in the not too distant future. And I think I'd be looking probably at a January setting. So I hope everyone's got their calendars.
I at least brought my calendar in, Your Honor. I did do that. I should say my legal assistant did that for me. I didn't do it.
Let me throw out the date of January the 19th at 10:30 in the morning.
Your Honor, because
10:30 a.m. from
That's December. Just a minute. They're looking at January, Michelle.
Yeah, I need January.
Your Honor, would be able to do it maybe
I didn't
around
hear your response, whatever it was.
That would be that way I could make sure I was done with court that morning in time for the hearing.
Okay, I didn't hear that. So, Ms. Williams, you want to say that again?
My apologies, Judge. I was just looking, I have a standing obligation on the 19th in the morning. I was wondering if we could go later, like 11 o'clock or 11:30, just to make sure I would be done in time to join this hearing.
11 o'clock's fine.
11, thank you, Judge.
11 o'clock would be fine, Counsel. All right, Mr. Weta?
I'm available on the 19th of January at 11 o'clock.
All right, Mr. Mills?
Yes, Your Honor, I would be available on that date at that time.
All right, and then last but certainly not least, Mr. Cranmer.
Yes, I'd be available. Judge, is this a status conference or is this a hearing on the motion?
I will call it that. That's a status conference. Counsel will be advised if I'm going to expect argument or presentation on any issue to make it a hearing as such. We'll review the status of the case at that time, and the court will do appropriate scheduling or as may be appropriate at that time. It's also at least possible that the court might be making one or more rulings and announcing those on that day. Especially as winter is. So Friday, January 19, 11 o'clock a.m., a status conference by Zoom in this matter. Mr. Webb, is there anything else that the court needs to address further at this time?
Simply, Your Honor, we did file a motion asking the court to look at our interim fees. But if the court's not keen to do that at this time, then we can push that off until later. But we are a significant amount of money into this case and would like to, well, frankly, it's the end of the year and I've got numbers that I have to try and do the best I can to meet. And we've done a lot of work on this case this year. So I am glad.
Was there any objection to his submission, counsel?
None from my
Is
client.
anyone objected?
No, Your Honor, not from my client.
Your Honor, I've not seen it. I've not seen any
Okay.
submission.
All right, then I won't make a sua sponte ruling here then.
Okay.
All right, I'll take a look at that, Mr. Wetta,
Thank you, Your Honor.
and
No,
make a specific note about that. All right.
And if
Mr.
you need
Mills, anything further at this time?
Well, Your Honor, the only thing I want to make sure of is that, procedural. I'm trying to be as I guess kind or whatever as I can be, but procedural. I'm not sure that we have been tracking with the procedure. I've not heard any response. I mean, I know you told me Mr. Wetta made some response to something, but I was not able to hear it. So I don't know what he said. I've seen no written response by Mr. Wetta to any of my motions. I haven't seen any response from Mr. Cranmer to any of my motions. And the responses that I've received from Ms. Williams were not, in my opinion, timely under the rules of civil procedure. So I don't think that any of the parties, to be quite honest, Your Honor, have had the adequate time to be able to address the other person's arguments and respond. And so I think that the court might be cutting off really all counsel a little bit before they can absolutely be able to respond, especially when we're having these cutting in and cutting out of the record here. And that's not anybody's fault. I mean, as far as the cutting in and cutting out, I'm not, accusing anybody of that. But all I'm wanting to make sure is that we all have an opportunity to respond or reply in some way to the other party's position. And I would welcome hearing the other party's case law that they think might affect this. And I know evidently Mr. Wetta must have tried to do that, and I just didn't get to hear it. But I may want to respond to what he had to say, but I don't know what he said, so I don't know if I have to. So
All right.
I'm just asking for the opportunity to be able to respond if need be.
All right. Mr. Wetta?
Yeah, I was just going to ask. Yeah, go ahead.
Here's what my suggestion was going to be. Can you give Mr. Mills a call after we conclude this meeting and give him essentially a summary of what you presented to the court regarding the Fechner case, your biology section of the statute that you referred to, and any other. And I think Mr. Mills should be entitled to hear what you addressed the court about. Are you in a position to do so?
Yeah, I can do well. Yes, I can do my best. If we wrap up here quickly, I can before I have to go get my kids.
Okay.
Yeah, I will be glad to.
All right, then I would just ask you to do that, counsel.
Thank you, Your Honor.
All right. Ms. Williams, anything else we need to address today?
No, Your Honor.
And Mr. Cranmer?
Nothing further for me, Your Honor, for today.
Very well. Thank you for joining the meeting. I know that you were pressed for time today, Mr. Cranmer.
Yeah,
right.
I was.
If there's nothing further, okay, go ahead, Doug.
I apologize for being late. I got here as soon as I could.
But again, your assistant was right on the meeting when they were supposed to be and essentially took your place and probably heard some things she regrets hearing, but nevertheless, we're concluded for today. Mandy, you can end the meeting at this time as the court.